my lord, I want to thank lordship for mentioning an item for admission, lordship, because entire bank accounts has been freezed, lordship. Earlier, lordship fixed the matter, but
Friday?
please, lordship. Much obliged, lordship.
Lordship, in item 1, I have filed an affidavit, my lord, on behalf of respondents, my lord, today. That may be called for me.
May it please the lordship. Lordship, I beg to mention for listing of a writ petition for admission column, my lord.
25th?
Lord, our clients are agreeable to 5-6 lakhs. They are all set.
You agreed. Okay, file a joint affidavit.
Yes.
Can you do it on Friday?
Yes, I'll not be there. My friend would be there.
We'll close it.
Kyle would be there.
On the basis of a joint affidavit,
Yes,
we'll
yes.
close it off.
Yes.
Fine.
Deep love.
It has been submitted that the parties have amicably settled the dispute and amicably settled the dispute. So considering the above, it is the opinion of this court that a joint affidavit be filed. Joint affidavit or a respective affidavits be filed by the parties
We'll file joint, Miller.
by Friday. List the matter on Friday at 2 p.m. for final.
Wrapping means, well, he has filed a review. Let a notice go in this, what will respond to.
May I just take your lordship to your lordship's previous judgment and one pending in the previous petition.
Now, if I review this order,
Yes.
means I have to recall that order. Once I recall the order, then you have to bring in by way of an affidavit in the main matter, because it is a case of new facts which came into light. So therefore, what is there to issue notice?
There are some things to which we'd like to respond. And maybe take a.
Now, the fact that which had come to him later on, which he could not produce at that point of time, is a fact which is admitted by you.
Yes.
Is it denied to the effect that this aspect came to light later on?
Otherwise not much. But
So
he
there-
had an option.
No.
Even at the time when he filed the writ petition, he had the option of collecting all these materials and then bringing everything together.
No, that is okay. But the fact that at that point of time he did not have, as it was not openly available, is a fact which is admitted. So therefore, we can take this very aspect and take it up, then you see the entire matter comes up together for final disposal. You see, they have raised this issue in the second writ petition. Now, once that is being recalled, only point is otherwise whether that point is there or not, it will be considered later on as to whether that point is there or not. But by my closing out here, I can't go and decide the second writ petition without first going into this aspect.
Yes. That is true. It is just a technicality, your lordship is aware, it's a ONGC. Just will take instruction if they want to file any affidavit or anything. Your lordship may have it within 2 weeks. If necessary, will respond and your lordship will pass this order. Otherwise, this we are not disputing that the fact has come to his notice later on.
So if that is so, this is the point which needs to be urged because we have already issued notice in the other matter. Only problem with the other matter is because of this judgment. So we recall this order and thereby put this thing open for in the other writ petition can be adjudicated.
Yes.
In fact,
Otherwise, I'm fully in agreement with your lordship, just that to overcome the technicality, in case they want to file anything. The lordship, have you,
Mr. Chaudhary, if you remember, that day, that matter where you were appearing against Mr. M.K. Chaudhary, as regards constructive res judicata, have you
Yes,
seen my judgment? I-
To be honest, I haven't read it, Milad. This morning only this copy was handed over.
Okay, so in that judgment, I have taken note of the judgment of 2014, judgment where it refers to various constitutional, constitution bench judgments, wherein it is categorically held that an issue which was there, which could have been raised at that point of time, if not raised, cannot be raised by way of a separate writ petition.
Subsequent petition.
Civilian. So therefore, that is the issue which was there, because at that point of time, he had the aspect pertaining to distance. Because the distance he came to know, I think, on 23/6/2020, and order was passed on 23/10/2022, and thereupon he challenged in the that writ petition. So
And
there-
in terms of, I think, explanation to section 11, Milad, it is also said, supposing there are several prayers and one prayer is not granted or not hesitating, then it will be presumed that that relief is also
Yeah,
denied.
that will come as regards explanation 5. But explanation 4 says that a thing which could have been brought,
Yes,
having not been brought, it shall be deemed to be a part of that suit.
yes. Something to do with akin to order to rule to CPC. If
Yes,
you have
or,
got several cause of
yes,
action,
in
then
fact,
you need
order,
to bring it in the one action.
yes, order to rule 2 is a procedure,
Yes, proceed.
but this is substantive.
Substantive, absolutely.
And in fact, that is why you find one judgment of Justice U.L. Bhatt. In fact, that judgment, I took it out at the point when you were arguing. I was assisting Dr. Saraf in that matter. You raised an issue of order to rule 2. But we have a single bench judgment of Justice U.L. Bhatt at that point of time that in a writ order to rule 2 does not apply. But this
In view of-
principle,
in view of the explanation to section.
but this principle as regard explanation 4 duly applies in writ.
Because it is substantive.
Yeah. In fact, I think Justice Bhatt did not take into consideration this aspect in that judgment.
Between that way, that is the substance.
It's an 80, 90, 88 or 90 judgment is Justice Bhatt. Okay.
Deeply.
May I just, for just assistance,
Huh?
for just assisting, may I place one judgment for just.
Judgment? Okay.
Just for, just for.
Judgment you want to place. Then you make it, I have to issue notice and finish.
Just for knowledge, for order to rule 2 only, though it's not applicable, para 25, your lordship.
No, see, what you are saying, there's no quarrel with that proposition as regards order to rule 2. If you don't know a particular thing would not come into the being. So therefore, you see, order to rule 2 bars you. It deems that you have relinquished. You have given up the right. Order to rule. Whereas explanation 4 to section 11 says something else. Explanation 4 to say that if there is a thing which you ought which was a part of the cause of action. And this particular cause of action, you have not agitated, or if it was not, or you have not mentioned, or whatever it may be, it shall always be treated as a part of that cause of action. And if it is the part of that cause of action, any order passed in that order shall be deemed that it had considered that part of the cause of action, and therefore explanation 5 comes into the bill. Although you have sought for the relief or not. So therefore, order 2, rule 2 is on the question of relinquishing. You give up your claim. Certain claims which you ought to have made, but you have not made. That means it will be deemed that we have given up. That is the procedure to the. But here, this is the substantive. So we allow this review.
Just the technicality, because I am specially engaged in this other matter. They may not want to engage me
Which one?
in this review, since it's a fresh matter.
Okay, he's
So-
there. Chalo, let us see the CPC. You can very well take except notice because you are a part of the earlier one. Don't come up with these technicalities. Kindly see order 2, rule 2, order 2, rule, order 3, rule 2. For the order 3, rule 4. Explanation. For the purpose of this rule, the following shall be deemed to the proceedings in a suit. An application of a review of an order or suit. That don't come up with this. He may very well say he is a senior counsel, you may not engage him. But here, what is this? So we allow this review. Recall the order. Not on the other aspect. Okay, you file your affidavit because there is, if I recall it, the other aspect also becomes open. Isn't it? That is another aspect, which if I recall the order, the other aspect which I have concluded becomes open. But we can very well, therefore, the review will be only stricter sensu to
this new aspect.
finding of new materials, not on the ground of error apparent. So if it is not there, if I'm not exercising the power under the first proviso, error apparent, then obviously it will be the second proviso. So therefore, only on the new material I have to look into it. So there won't be a problem as such. Because that is also the subject matter of the other writ petition. Anyway, you want to file affidavit. Okay. This is an application filed seeking review of the order dated of the judgment and order dated 26/9/2025, passed in WPC number 5768/2025. On the ground that new materials had come to light, which was not available with the petitioner at the time when the writ petition, being WPC number 5768/2025, was filed. Mr. Arsham, the learned counsel appearing on behalf of the review applicant, submits that the review sought for is limited to the ground of of discovery of an important matter, of new and important matter or evidence, which after due diligence, exercise of diligence was not within the knowledge of the petitioner. at the time when the writ petition, earlier writ petition was filed, as well as the judgment pronounced by this court. Taking into account the above, it is the opinion of this court that this is a fit case for issuance of notice upon the respondent to show cause as to why the review application should not be allowed. Mr. P. Borua, the counsel who represented the ONGC, accepts notice on behalf of the respondent who represented the respondent in WPC number 5768 of 2025, accepts notice on behalf of the respondent numbers 1 to 4. Extra copy of the review application be furnished to extra copies of the review application be furnished to him during the course by tomorrow. As regards the respondent number 5, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The respondent, anybody appearing for respondent number 5?
Yes,
So you are appearing?
yes.
Why are you delaying it? Mr. Dingia, the thinking, no problem with that. But with this court will remember this. Are you going to accept it or not? It's the same matter. We're accepting. As regards the respondent number 5, Mr. Dingia accepts notice. Extra copies of the so and so accepts notice for respondent number 1 to 4 and so accepts notice on behalf of the the respondents are given the liberty to file reply on or before 10th of June 2026. In respect to the instant review application, list the matter on 11th of June 2026. List the matter on 11th of June 2026 along with review application number 82 of 2026.
For further hearing, in the writ petition.
Review will come along with, I said, so this gets connected with that. So review will only come before me.
Of like,
Yes, Mr. Chaudhary,
Yes.
very huge matter.
May it please the lord.
Hmm.
My lord, the petitioner is an MSME unit, my lord. Is engaged in the business of manufacturing and procurement of oil field tools and equipments. Now, my lord, this particular work order for development and supply of control line, it's a device used in the drilling, my lord, was issued to the petitioner by the Oil India Authority. Now, the purchase order is dated 21/9/23. Then, my lord, the work was completed. And on 12/12/23, work completion certificate was given. But they use a different expression, my lord. They call it development order certificate. It's a work completion certificate.
Okay.
Then on 13/8/24, my lord, and
39.
13/8/24, an amended development certificate was issued. My lord, later part of 2024, warranty period was also over. Then, my lord, sometimes in 2025, based on the credential, that is the work completion certificate issued by the Oil India Authority, the petitioner participated in a similar work under the ONGC. And that work was awarded to the petitioner. In the meantime, my lord, one of the unsuccessful tenderer in the Oil India work, he filed some complaint against the petitioner.
The second one.
Yes. Alleging that, my lord, the whole thing is not made in India, that some of the component of the manufacturing processes were outsourced or something like that allegation was raised, my lord. Then eventually, my lord, on 15/1/26, the certificate, work completion certificate, which was issued to the petitioner, was kept in abeyance.
After being issued.
Yes. After work was, after 3 years. Now, my lord, because I got the ONGC work on the strength of that certificate, therefore I was in a precarious condition, my lord. Therefore, I immediately moved the Bombay High Court. Then Bombay High Court passed an order. If your lordship would kindly have a look at page number 105. Para 5 at page 105.
Yes.
After the petitioner tenders the representation and details, respondent number 1 would follow the procedure as is normally followed in such matters and shall arrive at a decision by assigning reason. Such a decision would be communicated to the petitioner. Now, this order is dated, my lord, 10/2/25. Then, my lord, we filed a representation pursuant to the order of the Bombay High Court, which is at page number 92. Now, in the representation, we have brought out our stand. Then, my lord, suddenly,
No. It
sorry,
can be because of the fact that your representation is dated 10/2/2025.
an order is dated,
3 February 2026.
yes.
How is it
No,
possible?
it's not pursuant, I'm sorry, my lord, it's not pursuant to, independent of that. Anyway, my lord, what had happened thereafter, by order dated 12/12/24, my lord. Sorry, 4/3/26, my lord. Page number 232, the
36.
232, my lord, it starts. And the operative portion is at page number 251, my lord. 250, para 14. Truwell has failed to satisfy the DOPO and tender requirements of being an original manufacturer, nor has it disclosed or claimed to be a vendor authorized by the original manufacturer, if any. Its own representation admits outsourcing of critical process and explains prior non-disclosure on ground of NDA confidentiality, confirming that oil's decision to award the purchase order and to issue the development order certificate was induced on incomplete, incorrect information. In addition, the information provided prior to the award of development order has been irrefutably found to be false in view of the admitted position in the representation. Misrepresentation by Truwell, in fact, attract clause 17 of the tender, warranting consequent legal action as contemplated thereunder. Oil reserves its right to initiate appropriate action in this regard in accordance with law. Order. For the reasons set out above, development order dated so and so along with the amendment are hereby withdrawn with immediate effect. So, my lord, net result was the development order certificate, or in other words, the completion certificate was withdrawn.
Then
So, my lord, we have challenged that order. Now, my lord, our limited prayer at this stage of the proceeding is, my lord, that they will withdraw this order, not even a show cause notice has been issued. There is not even a show cause, not to speak of
No,
giving us a
no.
hearing.
But the fact remains,
Yes.
there was a proceedings on 3/2/2026.
Yes,
An order passed by the Bombay High Court.
yes,
Bombay High Court's order was prior to the withdrawal or
yes.
after the withdrawal.
Well, post suspension of the certificate. Yes.
So the post suspension.
Yes.
And then you were allowed to submit a representation.
But, my lord, what was the charge against me? I must know, my lord. They have of their own, my lord, they have brought out all this. Am I not entitled to a charge? My lord, Bombay High Court, naturally, my lord, consistent with the principles of natural justice, Bombay High Court indicated you file a representation. But what was the charge against me? You have suspended this completion certificate, then you withdrew it. My lord, therefore, my only prayer is, my lord, at this stage, since we are concerned with the decision-making process, I'm not troubling your lordships with the merits of the decision. Let them submit a charge show cause notice. Let us give a hearing, my lord, because there is a bona fide dispute on the allegations.
Let us read the Bombay High Court judgment
Yes, my lord.
at page 103.
Yes.
What was the basis?
It starts at 103, my lord.
Yeah.
I'm reading from the second paragraph.
Yes.
Considering the order that we are passing in the light of what has transpired before us, we are not required to record the entire submission of the parties, since we may have to make certain observations which may not warranted at this stage. Suffice it to say that respondent 1 has carried out a surprise inspection on 4th of January 26 and pursuant thereto, notice dated has been issued to the petitioner calling upon it to furnish certain details and information sought for in the said notice. Learned advocate for the petitioner submits on instruction that petitioner would furnish all details and information sought by respondent number 1, along with the relevant document within a period of 7 days. The learned advocate for the petitioner further submits that petitioner is willing to tender a representation in response to the document, which is at page number 110, dated so-and-so, addressed by the Chief General Manager Contracts to the resident executive, which forms a part of the compilation tendered by the respondent number 1 along with an index. A compilation is delivered to the learned advocate for the petitioner. Petitioner expresses anxiety as regards the details of the contract and procurement of raw material from Messrs. Sandvik to be divulged to respondent number 1. Petitioner number 1 would not be able to divulge the details in view of non-disclosure agreement. Considering the issue before us in this petition, we direct petitioner to convey to the said supplier that this court had directed the disclosure of the details and that this would be kept confidential to the extent the issue involved in this matter. These details would not be subject matter of circulation to any other person or authority save except the subsidiaries and instrumentalities of the Government of India. After the petitioner tenders the representation, the the respondent number 1 would follow the procedure as is normally followed in such matters and shall arrive at a decision by assigning reason. Such a decision would be communicated to the petitioner. Needless to state that
It's very difficult to ascertain what is the matter
yes.
from the order.
Because other than that
Now
explanation,
what representation you submitted there?
yes. Representation, please.
You are filing the writ petition all over India. And why at the end you are coming back to Gauhati High Court?
What was submitted was in adequate dimension.
Huh?
Adequate directed us to go to Gauhati and record on the next location.
Means verbally.
Yes. The little bench over there of Justice Buge pointed out the jurisdictional issue right at the outset. But because there was an urgency and since 3 months we were under abeyance and an order was under abeyance, he said, I'm not going to admit it, but you can file your representation. Just time enough to grant the that.
But wouldn't that be amounting to exercise of jurisdiction by the Bombay High Court?
They would not want to comment.
Anyways, Mr. Chaudhary, where is your representation?
Yes.
After the Bombay High Court.
Also, they have to please, about it. One second, Miller. ऐसे हो सकता है। नहीं।
I think this is dated wrongly. Page 92 is the
92, Miller, that's what I got confused.
No, but the date has been wrongly put, I suppose.
Yes, yes.
The dated, the order was passed
In the
on.
past, post Bombay High Court order,
The order, it should have been 10 to the
26.
10 to 26. B.
Page 92, Miller. Milord, kindly see, we sought to clarify our position in what manner we are saying that we still maintain the status of Make in India. So these are all bona fide, Milord, disputes, Milord. How can without notice, without hearing, these issues can be solved? So all that we are insisting is, Milord, let them give us
So
a full
this
scale
is
hearing.
on the basis of this submission is, or you went to the Bombay High Court on the basis of some inspection being carried out.
And no, and also,
Okay,
my lord,
yes,
that
from,
also that
kindly
suspension
please,
order.
We refer to the factory inspection report, pursuant to which our development order has been placed in abeyance.
Events.
We have further submitted that we have been specifically directed by Bombay to submit the present representation to the Oil India for their consideration. And the outset so and so forth. Pursuant to and in compliance with the above and the restrictions no longer survive. Accordingly, we are now placing on record the materials here for it and without a reservation, clarifications made and
So, my lord, page 92 representation, we have tried to explain the position. Now, my lord, our only concern is, my lord, in a matter of this nature, there must be specific, my lord, pointed queries as to in what manner we have deviated. Then we should also have a right of hearing. And we asked for a hearing which was never given, my lord. If proper opportunity would have been given, my lord, we could have explained the position why we are still maintaining the Make in India character. So our prayer is, my lord, this order should be interfered with. We should be given an opportunity of hearing, and my lord, they can pass a fresh order. Prima facie, my lord, there is no notice, no hearing.
This is page 68. What is this document?
68, my lord. This is a fifth. This is abeyance, my lord. Order of abeyance.
So this order, you have not challenged it anywhere. This 15/1/2026.
No, my lord, eventually it merged with the final order, my lord.
So this is the keeping in abeyance.
No,
is also
in this proceeding, we have challenged both, my lord, abeyance order as well as
in the Bombay High Court.
here also. Here. No, Bombay High Court, we challenge only the abeyance order.
So this 15/1/2026 was challenged in Bombay High Court.
Yes.
And thereby you have been asked to submit a
Submit a
representation.
representation.
On the aspect pertaining to the abeyance.
Only on the aspect of abeyance.
Are you sure?
Yes.
The moment you say that.
Because, my lord, the final order came subsequently. Bombay High Court order was of 3rd of February, Milord. And the final order is at Milord 4th of March 26.
Anybody has a Bombay High Court petition? Well, that is important.
Even we have, Milord.
Yeah,
Even-
can you provide us? Because that is the issue. Now, what did you ask out there?
Ha.
It is important taking into account that because here this seems to be the genesis. 15/1/2026 seems to be the origin.
Yes.
On account of a writ petition being filed by some person, classic oil field.
Classic oil field,
questioning-
supplies and services.
Questioning your the tender
Credential.
which have been given to you. They have filed, and therefore they have kept it in abeyance. Now thereafter, what Bombay High Court, with due respect, did not
Bombay
mention what
order
the
is,
fact.
my lord, to be honest.
They didn't mention as to what is the facts. Nothing is
Only
mentioned
liberty
of
was
it.
given to my lord file a representation.
So now representation is in respect to what?
Lordship, just to clarify in a nutshell, this particular order has gone to 3 High Court. Delhi High Court, Bombay High Court, and Gauhati High Court. I summarized the entire issue. In the month of September 2025, we received an ONGC order. We gave L1. Classic oil field gave L2. He went to the IEM, filed multiple complaints, went to the CLCU, no relief was granted. He files a writ petition in Delhi High Court, does not make us a party. Because he was a successful bidder, he ought to make us a party. He gets notice issued, and in the second hearing in the month of October, he prays to implead us into the writ petition. He does not issue us a notice. We are unaware of such proceedings being going on in Delhi High Court. In the month of November, there is an inspection by Oil India. We are in the process of shifting to a bigger unit because this tender, this order certificate was of 31 lakhs. The other, the order we received from ONGC is of 41 crore rupees.
A new one.
Yeah, the new one, which is ongoing and is at complete standstill because of this particular certification. Now, because of that issue, the Delhi High Court completely did not just issue a notice, and Oil India had a surprise inspection without any notice, comes to Bombay, one member team, and says, we want to visit your factories. They come, they visit, make an internal report, do not get back to us. We think everything is fine, and we continue without. This is in the month of November. In the month of January, 3rd January 2026, we specific, we receive another email, no notice, an email that an oil member of 6 members are going to come to a factory on 4/1 January 2026. Please make necessary arrangements. No notice, nothing. We informed that we are shifting our particular facility. Is there anything specific you would want to do in this thing? They do not highlight anything. Once that is done, on 4/1/2026, they come to us. They see certain equipments are packed, certain machineries are in transitional state. They go to our older factory, we take them to our older factory, come to a newer factory, take pictures, do everything. Tell us, we need 2 documents. One is your source of billets, and there was another document. Give us these 2 documents on an email, not on a notice. On that email, and we will see whatever has to be done. Naturally, we informed them that we have a factory inspection going on for ONGC. The product is being inspected, and we need to give the first lot because ONGC has emailed because it is an oil drilling project and now it is sensitive right now. So they wanted it in an urgent manner. Now what happens is they directly pass an abeyance order on 15th January 2026, citing 2 reasons. That you are a party in Delhi High Court until those proceedings come to a standstill where they have no owners. They are neither a party. We are a party we did not know about. And one is that reason. And second reason, we asked you for certain documents on the factory visit, which was surprising. You did not provide to us. So on these 2 bases, we are providing you with an abeyance certificate, putting our entire order at stake. Now what happens is, sir, we issue a notice to Classic Oilfield that if you made us a party by having you issued us a notice or delivered anything. We approached the Delhi High Court. The Delhi High Court order is annexed over here. Delhi High Court said
You
that
challenged this 15-1 before the Delhi High Court.
15-1, we did not challenge it, Your Lordship. They say in their letter of 15-1-2026, because you are a party. to
No,
this-
that I understand.
Yes, sir.
Now 15-1, what happened?
15-1, they suspend us.
Then
Once they suspend us, we issue a legal notice to them. In reply to that particular abeyance certificate, we issued two notices to them. One clarifying the stand that we had no idea, notice has been issued to us, nothing has been received by us in the Delhi High Court. We will take appropriate steps before the Delhi. We don't mind that. And the second thing is we gave a notice for damages. Now, notice for damages when it was given, we had indicated we will withdraw it once we do not intend to do anything to Oil India. We only intend our certification because an order of 41 crore has already been executed and is ready to be delivered. So it's already a civil debt situation for us. And every passing day is very important for us. What they do, sir, is we go to the Delhi High Court, we pray before them that, sir, we issued a notice. We are a party, we were not aware over there. Classic over there makes us
so
submit.
you go to the Delhi High Court in the requisition filed by Classic.
Yes, sir. We filed an intervener application because we were not aware that we were included in. During the intervener application hearing, Delhi High Court said you were included. So accept notice. Why do you want to be an intervener? We said okay. We said these here are the merits. They said file an urgency application. We file an urgency application that we have to be heard because we are put under abeyance because of this particular petition where there are no merits.
So there is no challenge by you to 15-1 there in Delhi High Court.
No.
Now what happened thereafter? Why did you come to Bombay?
That we came to Bombay only for a specific. We were put under abeyance. Our entire workstation was in Vasai, which is Maharashtra. We completed the entire product over there. Only it was shipped to Duliajan in Assam. We took that aspect into account and we approached the Bombay High Court. We wanted a very limited prayer clause that if we are put under abeyance for two reasons, the Delhi High Court writ petition
What did you challenge in Bombay High Court?
only the abeyance certificate.
So you challenged the 15-1-2026. Now the court said that you go and submit a representation.
The court was very highlight, which I would like to admit to this court. The court said, we will not admit this writ petition for a very fact that there is they raise a jurisdictional issue on two grounds. One, there is an arbitration clause. And second, the work was to be delivered in Gauhati, which is Assam, Duliajan. So it is not a jurisdiction.
But there is not a single whisper in the order pertaining to the jurisdiction.
My learned friend was present in the virtual hearing. He can apprise the court.
It's okay. Virtual hearing, whatever happens, in fact, in a recent judgment of the Supreme Court says that whatever you say with dictated the court would not have any impact unless it is a signed order following the 1952 judgment of the Supreme Court. But anyway, be that as it may. So thereupon, the Bombay High Court allows you to submit a representation. You submit a representation giving explanation to everything. Now what they do is, this is your representation submitted against the abeyance.
Yes.
Now what they do, after getting the representation, they finally dispose it off and strike it.
And that disposal comes through twist and turns of our own representation.
That is a
Not through
different.
reason.
Let us not go into that.
Yes, Your Lord.
Yes, Mr. Saikan.
So they are happy with the order passed by the Bombay High Court. They have complied it. Now they cannot turn back and say that that judgment did not consider all the aspects. regarding
I'm not
notice.
on that. The question is, when did you take a notice, give him a notice that you are going to cancel it?
Because we have suspended, then the proceeding would have started.
Then why didn't you start it?
No, there is no occasion for us to start it because
But
Bombay,
then if
we have
there-
followed
There
the.
was no occasion, whatever may be, there are certain civil rights involved on the basis of the DOC which has been given to them. So therefore, it was your duty on their part that, okay, we are issuing a show cause to you, why we should not cancel. On
The
your
issue
own,
is-
you put it on abeyance. Okay, abeyance is something like a suspension, you have the power to do so.
It is just like what we do in the normal civil service matters. We suspend him, then issue the so cause, frame the charges. That would have been an ideal situation. That has not taken place because they went ahead. They preempted that position of us. They preempted our exercise of going through a proper legal process. They went to the Bombay High Court and they have not challenged the Bombay High Court's order. Rather, they complied the Bombay High Court's order.
Now, Bombay High Court said that you submit a representation in pursuance to the keeping in abeyance.
Yes,
But you could have said that, okay, we continue to keep in abeyance this for till the disposal. That
top
was
of
the
that, Lord.
hope you had.
We
But you
would have
could
done
not
it.
have
We
cancelled
would
the
have done
entire
it otherwise if they had not gone to Bombay High Court. They have gone and there is a direction from the Bombay High Court in presence of our council, and it was an agreed order from them. If Lordship is allowed,
No,
me to-
understood.
they agreed to it.
Mr. Zaki, I understood everything. The fact remains, the Bombay High Court said that go and submit a representation before the OMG's oil out there as regards 15/1/2026.
Yes. Let us see that representation now.
No, it's okay. They submit a representation for only 15/1/2026. You could have very well say, okay, representation.
Let us
rejected.
read
But you
15:1
went the furthest
and
step.
their representation,
Yes.
what their representation consisted. Let us read
They
that.
have made it. I read it. just
They
now.
have done, they have indicated everything in their representation. It would have been a futile exercise if you have faced cause of notice, so-called notice, Lordship. What we have dealt, because it is an open and shut case. Now, one more thing. Let us not take into that account. One document they have placed before this honorable court. Let us place that document first. How they are trying to pull this honorable order. They have taken recourse to fraud. Here also. That page 64. Lordship will enter into the merit after they can clarify this. Page 64. The whole issue is that place of origin of the manufacturer. Lordship will see certificate of origin, manufacturer down below, India, materials origin, India. In our affidavit, we have annexed the documents which is submitted to us by the concerned authority that company is
Classic.
Elima. So Lordship will kindly come to page 381. 38.
Yes.
381 Lordship, the email communication started from 381. First, let them clarify this.
What is this?
It starts from 381, then 385 Lordship will come. And the main document which I am relying to is page 389. The manufacturer is Canada, metal origin Canada. So these documents they have submitted before they are doing a Pavan Khera case here, Lordship.
What case?
Same thing is happening here. So if this kind of things are happening in this court, this honorable court will first take recourse to this, and in their reply, they have not denied it. They are doing fraudulent activities from day one itself. They misled some of our officials also in 2023. First, let them reply to this, Lord. Then they are not denying in their rejoinder.
But Mr. Sekhar, do you think that this court will look into this aspect?
Yes, Lordship.
Why?
This, because these are part of.
Better, why? You have good experts. You
Yes,
look
we
into
have good answer. Therefore, this is a
You
case
look
of
into it.
disputed facts.
Ask him to
No,
explain.
I'll leave it to you. If
This is-
Lordship
but-
accept the
but-
fraudulent
but
document here.
Mr. Sekhar, this is the thing which you being experts, you ask him to put him to notice that why you have given all this thing. I'm not going to look into it. The
Because they
fact
have given it to this honorable court.
understood, but whatever may be, the question is this.
Lordship is
these-
ignoring this document.
But,
I have no comments
but
to offer.
Mr. Sekhar, this document or the document which you are showing at 389 goes just above my head. I
Yes,
don't
that is
understand.
why when there, yes.
It is not for me to
Absolutely,
understand.
Lordship.
I can,
I
on-
fully agree
I,
with Lordship's
I can
view.
only see out here that the
No, no, I-
product is this and the product
Yes.
appears to be same.
Absolutely, Lordship.
That is what
Therefore,
I saw.
when there is a question of disputed facts,
Here the question is not those. The question is out here is, you initiated, you on the basis of an inspection being carried out, passed an order on 15/1/2026.
Yes.
Saying that we are keeping in a bit.
yes, that was put to challenge and that was not
It's okay,
interfered.
it's okay. They put to challenge 15/1/2026 before the Bombay High Court.
Right.
Bombay High Court said, oh, you submit a representation there, we are not going to entertain this petition
Yes.
otherwise. You could have rejected the representation. Very well. And kept the abeyance in order, kept the continuation of the abeyance. But you went a further step ahead to cancel it without a notice. That is the only thing. That is the only aspect. Better do it. Do it within 45 days. Finish it off. He will go and you submit a so cause, he will do it. In the meantime,
The abeyance will keep in.
it will keep in abeyance.
Yes. Then I am agreeing. In that situation,
I'm not going to challenge the, I'm not going to touch the abeyance because this is the
just one
point
second.
on which I am going to interfere.
if the abeyance is fine, Lordship, we have no objection.
Abeyance, you see, abeyance is a form of a suspension. Abeyance is a form of a suspension.
Yes.
At the end of the day,
Yes.
what
we'll do
you
the
have done
exercise.
is
We'll
you have
give full
terminated him.
opportunity. We'll give
So
full opportunity.
therefore, you are required to follow that or put him to notice to that effect. But you are going to give within 7 days, 7 or 10 days. Mr. Saikia, you are going to give his so-called notice within 10 days.
Lordship will fix a date of 30 days. We'll dispose it of, provided he cooperates.
No, I can't dispose it of unless you put the so-called. You see, I am
No.
interfering on the
Lordship may
basis.
give a timeline also.
You give us therefore submit. How long will you take to give him a show cause?
My only thing is,
30
Lord,
days.
You take 30 days for giving the show cause.
Yes. No. We'll give that so cause in 7 days. And
Then
we'll
he will
dispose of.
reply. He will reply within 15 days. Give him a
Not-
time 15
And
and
personal
give him
hearing
a
also. if
personal
they want.
hearing and matter is
Everything.
personal hearing.
Everything. But that January's order will remain intact.
that I'm not going to touch it now
Yes.
because that is the subject matter.
Exactly, Lordship. I fully agree.
Because if I touch it, the problem is the Bombay High Court is the
Lord,
problem.
I have only
You
one.
should have come before me before. You directly went to Bombay High Court.
Lord, I have a small prayer. Lord. Now, because of this suspension order, it is having an effect on my ONGC work also. So whether, my Lord,
You'll be entitled to escalation because if their actions are bad,
eventually.
eventually.
They
or
already
damage-
claim 100 crores from us.
No. So therefore, he will be entitled to a damages escalation
Yes, they
if
will
something
be entitled.
happens out there.
Fully, Lordship.
And
If
they-
we have
and
wrongly done it.
It is the work of oil which they are asking. Because of their actions, you are not. Section 48 of the Contract
Right.
Act will come.
The only thing is, my Lord, regarding the damage which you have claimed, that we are prepared to withdraw subject to the outcome of the case.
That
We are happy to
why
wait.
I will do
We
it
are-
when Chief Justice gives me bench one. Okay. Heard Mr. Kane Chaudhary, the Lalit Senior Counsel appearing on behalf. The Lalit Senior Counsel assisted by so and so appearing on behalf of the petitioner. Mr. D. Saikya, the Lalit Senior Counsel assisted by so and so appears on behalf of the respondent number 1. Mr. S.S. Roy appears on behalf of the respondent number 2. The petitioner, the present writ petition has been filed by the petitioner challenging the orders dated 15/1/2026 issued by the respondent number 1, thereby placing the development order certificate dated 12/12/2023 as well as the amended development order certificate dated 13/8/2024 in abeyance. The petitioner have also assailed in the present writ petition the speaking order dated 4/3/2026, whereby the respondent number 1 had withdrawn the development order certificate dated 12/12/2023, as well as the amended development order certificate dated 13/8/2024. Itu upar preface. Heading. Third dollar I wait. Conspectus of facts. The petitioner is an MSME Is a small or what? Small, large, medium?
MSME.
Is a medium. Is a medium enterprise coming within the ambit of the medium medium small micro enterprise act 2006. Full. The petitioner was issued a purchase order number 78000170/IDN dated 21/9/2023 for development and supply of control line products and allied accessories. Full stop. The petitioner claims that the petitioner had completed the said work in the year 2023 itself. Pursuant thereto, a development order certificate dated 12/12/2023 was issued by the respondent number 1. Full stop. Subsequent thereto, the said development order certificate dated 12/12/2023 was amended and a fresh development order certificate being amended development order certificate dated 13/8/2024 was issued to the petitioner. Where is the contract you have entered into? New contract?
With the NCC.
Huh?
Purchase order was in 2021.
Not on that.
No, NCC.
The new one, nah?
4th September 2020.
You have not mentioned anything. Why haven't you mentioned? Because that is the basis. No? It is seen from the materials on record that a writ petition was filed by one Classic Oilfield Supplies and Services against the respondent number 1 before the Delhi High Court, which was registered and numbered as writ petition number 14056/2025. The said writ petition pertained to a notice inviting tender dated 13/3/2025 for work of procurement of 1/4 inch and 3/8 inch control line along with fittings and accessories. Full stop. The petitioner herein was a party to the said writ proceedings.
But not party originally.
Mr. Counsel, first of all, you don't mention anything out here in your writ petition. And now you are saying impleaded and non-impleaded and all. You don't mention even about anything about this writ petition also you don't mention.
It's mentioned in paragraph 28.
About
28.
what do you say?
This statement in year 2005, he was given a contract. In 29, we mentioned classic oil.
28.
Yes.
28 is no, there is no contract you are mentioning.
Page 17.
Paragraph 17, paragraph 20.
There are petitioner in 2000 petitioner participated in here. There is no mention to that. Anyway. The records also reveal that on account of certain complaints received by the respondent number 1 about the capabilities of the petitioner to manufacture product as per the development order policy of oil. An inspection was carried out on 4/1/2026 to understand the manufacturing process vis-a-vis the EOI dated 6/9/2023 and the development order policy of oil and Make in India initiative of the Government of India. It is the case of the respondent number 1 that the petitioner could not conclusively establish that the products supplied to respondent number 1 had been completely indigenously developed. First, it is under such circumstances, on account of the reports, some reports submitted pursuant to the inspection carried out on 4/1/2026, as well as in view of the writ petition pending before the Delhi High Court, being WPC number 14056/2025. The respondent number 1 issued a communication dated 15/1/2026, thereby keeping the development order certificate dated 12/12/2023 and the amended development order certificate dated 13/8/2024 in abeyance pending the outcome of the court proceedings and the completion of the internal verification. It was also mentioned in the said communication dated 15/1/2026 that pending the said verification and the court proceeding, the petitioner shall not be considered for any further development activity by the respondent number 1 and was further directed to cease all activities related to the efforts above related to the development order certificates forthwith. First, now have you mentioned anything that you went to Delhi High Court? No.
In our rejoinder, we have.
You have mentioned.
A short affidavit have been filed.
The records further reveal that the petitioner was unaware of the Delhi High Court proceedings being WPC number so and so, and therefore filed an application before the Delhi High Court seeking impediment,
Intervene.
seeking to intervene in the said proceedings. First, however, taking into account that the petitioner was already a party in the said writ petition, the petitioner accepted the note. Petitioner was asked to accept notice, and the said proceedings continued thereafter. It is the further case of the petitioner that thereupon the petitioner approached the Bombay High Court by filing a writ petition challenging the order dated 15/1/2026 as well as the inspection which was carried out on 4/1/2026. The said writ petition was registered and numbered as the writ petition L number 1732 of 2026. The Bombay High Court, by an order dated 3/2/2026, did not interfere with the order with the communication dated 15/1/2026. Rather, asked the petitioner to submit a representation. The record further reveals that on 10/2/2026, the petitioner submitted a representation. A perusal of the said representation reveals that the said representation was in the context of the visit which was conducted on 4/1/2026, as well as the communication dated 5/15/1/2026. In pursuance thereto, the speaking order was passed on 4/3/2026 by the respondent number 1, whereby the respondent number 1 not only respondent number 1, instead of deciding as regards the grievance of the petitioner qua the note communication dated 15/1/2026, went further ahead to cancel or withdraw the
Development
Declare-
order certificate.
huh?
They call it development order certificate.
development order certificates dated 12/12/2023 and the amended development order certificate dated 13/8/2024. It is under such circumstances the present writ petition has been filed. The record reveals that this court, by an order dated 30/3/2026, issued notice there was no interim directions passed. However, it was observed that any further action taken on the basis of the order dated, impugned order dated 4/3/2026 would be subject to the outcome of the writ petition. The records further reveal that in the meantime, the respondents, number 1, had filed an affidavit in opposition on 28/4/2026. The petitioner had also filed 28/4/2026, thereby justifying the communication dated 15/1/2026, as well as the speaking order dated 4/3/2026. The petitioner had also submitted a affidavit in reply on 7/5/2026. Thirdly, he was submission of the learned counsels appearing on behalf of the parties. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that the issue involved in the instant learned senior counsel appearing on behalf of the petitioner submits that the issue involved in the instant proceedings lies within a short campus, taking into account that the development order certificates, which were issued by the petitioner, in favor of the petitioners, dated 12/12/2023 and 13/8/2024, were certificates by which certain rights were created in favor of the petitioner. On the basis of these development order certificates, the petitioner were able to get contracts from the various entities, including the Oil India Limited, including the respondent number 1. First, the learned senior counsel therefore submitted that as rights accrued on the basis of the development order certificates, the said rights could not have been taken away by the respondent authorities, more particularly the respondent number 1, without issuance of a show cause notice to the petitioner. He therefore submits that the very action on the part of the respondent number 1 to withdraw the development order certificates dated 12/12/2023 and 13/8/2024 are in violation of the principles of natural justice, which is a facet of Article 21 of the Constitution. Per contra, Mr. D. Saikia, the learned senior counsel appearing on behalf of the respondent number 1, submits that the petitioner herein had misled the respondent authorities at the time when the contract was initially awarded in the year 2023. And this led to the issuance of the development order certificates in favor of the petitioner. As the development order certificates which were issued in favor of the petitioner was on account of a fraud being committed by the respondent, by the petitioner, there accrued no right of the petitioner over the said development order certificates. And therefore, the speaking order dated 4/3/2026, by which the development order certificates were withdrawn, do not call for any interference. The learned senior counsel further referred to a certificate which had been issued in respect to a product under the name of the petitioner to be manufactured in India, which is at Annexure F to the writ petition, and further submitted that the said product in question, actual certificate, is at page 389 of the writ proceedings, which would show that the said product was actually manufactured in Canada. He therefore submitted that these aspects that the petitioner have also, he therefore submitted that the petitioner, therefore, having submitted a false document before this court, is therefore not entitled to any relief as have been sought for in the present proceedings. Anything more?
No, basically these are my.
Analysis and determination. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The facts above delineated would show that in pursuant to completion of certain work regarding supply of development and supply of control line products and allied accessories in the year 2023, the petitioner was issued a development certificate initially on 12/12/2023 and subsequently an amended development order certificate on 13/8/2023.
24. 24.
24. 13/8/2024. First. These development order certificates, as submitted at the bar, are in the form of completion certificates. And these under such circumstances, these certificates are used and the petitioner have used it for its credentials. The materials on record show that on 4/1/2026, the materials on record show that in the year 2025, the petitioner was awarded another contract based on these development certificates, which were issued on 12/12/2023 and 13/8/2024. The materials on record also show that on 4/1/2026, an inspection was carried out. First, whether the petitioner was given an opportunity to explain or not are questions of facts which this court cannot entertain at present. Be that as it may, it is the case of the respondent number 1, as would be seen from the communication dated 15/1/2026, that the respondent number 1 was not satisfied upon carrying out the inspection. To the effect as to whether the petitioner was capable of manufacturing those products. It is also seen that on account of a writ petition being filed by one MS Classics,
Classic Oilfield Supplies and Services Limited,
being WPC number 14056/2025, wherein certain allegations have been leveled against the petitioner. The respondent number 1 had issued the communication dated 15/1/2026, thereby keeping in abeyance the development or the certificates dated 12/12/2023 and 13/8/2024. Till the pendency of the writ petition, as well as the very internal verifications being carried out. First, the petitioner had challenged the inspection which was carried out on 4/1/2026, as well as the order dated the communication dated 15/1/2026 before the Bombay High Court in WPC number in writ petition bracket L number 1732/2026. The learned division bench of the Bombay High Court did not interfere with the communication dated 15/1/2026. Rather, asked the petitioner to submit a representation. Taking into account that the Bombay High Court did not interfere with the communication dated 15/1/2026, it would not be proper on the part of this court to cause an interference to the communication dated 15/1/2026 in the present proceedings. First, the records further revealed that the petitioner thereupon submitted a representation on 10/2/2026. As per the liberty so granted by the Bombay High Court in the order dated 3/2/2026. First, in the opinion of this court, the respondent number 1 could have at best rejected the representation, or the respondent number 1 could at best have rejected the representation by confirming to the communication dated 15/1/2026. But to the shock and surprise of this court, the respondent number 1 had went a further step ahead, thereby withdrawing altogether the development order certificates dated 12/12/2023 and 13/8/2024. In the opinion of this court, this course of action on the part of the respondent number one violates the very mandate, violates the principles of natural justice, inasmuch as there was no opportunity being given to the petition as to under what circumstances action was resorted for cancellation, for withdrawing of the development order certificates. First, it is settled principle of law that unless and until the noticee is brought to the noticee is informed about the allegations, it cannot be said that a reasonable opportunity has been provided to the noticee of answering to the allegations. First, considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, this court is not interfering with the communication dated 15/1/2026. Number two, this court interferes with the order dated 4/3/2026 issued by the respondent number one. Number three, taking into account that by virtue of the communication dated 15/1/2026, the petitioner, the development order certificates dated 12/12/2023 and 13/8/2024 have been kept in abeyance. It is the opinion of this court that the respondent number one is required to take appropriate steps either to withdraw the abeyance as mentioned in the communication dated 15/1/2026 or initiate a show cause proceedings upon the petitioner. First, Mr. D. Saikia, the learned senior counsel, Mr. D. Saikia, the learned senior counsel, appearing on behalf of the respondent number one upon instructions provided by so-and-so appearing on assisting him, submits that within 10 days, within 10 days, a detailed show cause notice would be provided to the petitioner. First, it is also he also submitted that the petitioner would be provided another 15 days from the date of receipt of the show cause notice to submit a reply. First, taking into account the above, submissions so made by the senior counsel appearing on behalf of the respondent number one, it is also the opinion of this court that the petitioner should be provided a personal hearing. First, it is next. This court observes that the respondent number one should expeditiously dispose of the said show cause proceedings, and preferably within 2 months from the date of the present order.
Subject to cooperation from the other side.
Therefore, I am not directing, observes.
Deeply.
He will obviously, it is in abeyance. Why won't he? He will next day submit. Mr. What's your name?
Faiz Khan.
Mr. Faiz Khan. So Mr. Khan would be on first day, on next morning only he will submit them.
Alia.
Yes, what is this?
The review application, Your Lordship.
Why?
Lordship, when this honorable court passed the order, Lordship, I have not annexed the inspection report at the time, Lordship. Lordship. Annexure, Lordship, Annexure 18, page 38, Lordship.
Page?
Page 38, kindly peruse. Page 31 para. Now let this court take into consideration the second aspect of the matter for which the eligibility certificate of the petitioner was denied. That is, upon inspection being carried out on 30/9/2021, the petitioner's industrial unit was closed and the machineries were deteriorated and were in rusty condition. But Lordship,
Why should we review it?
Only that lordship, my prayer is limited. That when the pronouncement, the judgment lordship, the inspection report is not
The
with me.
fact remains that you went into commercial production on 21/3/2017.
Yes, lordship.
They made the inspection in the year 2022,
Yes, lordship.
and your factory was closed from the year 2020.
Yes, lordship.
You started sometime in the year 2023.
23, lordship.
But the fact remains that it was the mandate that you had to have continuous production within from 5 years from the date of here. There was no continuous production.
At that time, also COVID is.
Not COVID period. There's no COVID period. There's no ground for that. There's no ground. Chalo, we dismiss it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant. Mr. So-and-so appears on behalf of
Respondent number 4.
the respondent number 4. You appear? You're not here.
We don't make.
Hello, we don't discuss it.
I.
Are you going to appear or not? Mr. So-and-so appears on behalf of the respondent number 1, 2, 3, and 5. Mr. So-and-so appears for respondent number 4. This is an application filed for seeking review of the order dated, judgment and order dated
18/11/25.
18/11/2025, whereby this court was not inclined to interfere with the minutes of the 14th meeting dated 28/2/2022 of the state level empowered committee for grant, whereby the grant of the eligibility certificate to the petitioner was rejected. This court also held that the petitioner that the also was not inclined to interfere with the impugned communication dated 9/5/4/2022. The learned counsel appearing on behalf of the review applicant had submitted that the present case is a case where the petitioner have discovered new and important matter, new and important materials, which the petitioner could not produce in spite of due, which the petitioner could not produce at the time of filing of the petition or even at the time of delivering of the judgment in spite of due diligence. And therefore, the instant review application ought to be allowed. The learned counsel therefore referred to an inspection report dated 23/1/2024, whereby
23, lordship. 23/01/2023.
23/1/2023,
Yes, lordship.
23/1/2024, and therefore submitted that a perusal of the said inspection report would show that the petitioner's unit had restarted the unit on August 2022 and started their production on December 2022. It was also mentioned that on 23/1/2023, the petitioner's industrial unit was in running condition and the production was going on. He therefore submits that in view of the said inspection report dated 23/1/2023, the judgment and order dated so and so be reviewed. This court have duly taken note of the said inspection report. And in the opinion of this court, the said inspection report has no relevance, taking into account that in terms with clause 10.7 of chapter 10 of the industrial policy, taking into account subclause 14 of clause 1.8 of chapter 1 of the industrial policy, mandates that it is only when there is a continuous production of 5 years from the date of commercial production, the industrial unit would be entitled to the various incentives. In the instant case, it is an admitted case. It is the admitted case of the petitioner that the date of commercial production of the extended unit was on 21/3/2017. The said, it is also an admitted case that the said industrial unit was closed in the year 2020, and on the date of the inspection which was carried out, on 39 on 30/9/2021, the petitioner's industrial unit was closed and the machines were deteriorated and were in a rusty condition. Under such circumstances, the petitioner do not satisfy the requirement of having continuous production for the last 5 years from the date of the commercial production, from the date of start of the commercial production, that is on 21/3/2017. Furthermore, a perusal of the inspection report only shows that the petitioner further to that, the perusal of the inspection report dated 23/1/2023 only mentions that the inspecting officials were informed by the personnel that they restarted the unit on August 2022 and started their production from December 2022. The inspection report do not in any manner state about any documents being shown, placed before the said authorities, that the unit the unit was restarted in August 2022. Even otherwise also, in the month, even otherwise also, even assuming for argument's sake, the unit was restarted in the month of August 2022, the said do not fulfill the requirement of having 5 years of continuous production from 21/3/2017. Under such circumstances, this court is of the opinion that the inspection report cannot be considered of any relevance, a relevant material for the purpose of reviewing the present judgment and order dated so and so. Accordingly, the review application stands rejected. Cost. Yes, what had happened? One person was not inclined.
Settlement has narrated. Subsequently, settlement was narrated.
Finished. You have the any affidavit file?
Page number 4.
There are two affidavits filed, huh? One joint affidavit filed on 5/3/2026 and the other filed on 30/3/2026. Which heard Mr. A. Das Gupta, the learned senior counsel, assisted by Mr. B. Prasad, appearing on behalf of the petitioner. Mr. S. Das appears on behalf of the respondents. The present application has been filed. The present petition is filed challenging the award dated 9/7/2010 passed by the Learned Labour Court, Assam, in reference case number 12/2009. Which one? The award is dated what? 10. 10, na? The record reveals that during the passage that pursuant to orders passed by this court, on 3/2/2026, two joint affidavits have been filed on 5/3/2026 and 3/30/2026. Whereby it is seen that the dispute involved between the petitioner and the respondents have been amicably settled. You have got the money. Huh? It's mentioned. From a perusal of the affidavit, joint affidavit filed on 5/3/2026 between the petitioner and the respondent number? In page 196. It is between joint affidavit filed on 5/3/2026. It is seen that a memorandum of settlement have been entered into on 25/2/2026 between the petitioner and the legal representatives of late Shashi Mohan Roy and Sri Pavitra Kumar Roy, whereby it is agreed that the legal representatives of late Shashi Mohan Roy would be paid a one-time final settlement of rupees 30,000, and Sri Pavitra Kumar Roy would be paid a full and final settlement of rupees 28,000. The records further reveal that another joint affidavit was filed on 30/3/2026, whereby a memorandum of settlement dated 28/3/2026 was brought on record, and in terms with the said, an amount of rupees 31,682 would be paid to Muhammad MD Muhammad Ali in full and final settlement of all the claims. This court have duly perused the terms, the joint affidavits, as well as the terms of settlement. And in the opinion of this court, the same have been entered into without any fraud or coercion. Considering the above, this court therefore deems that settlement have been reached between the workman between the petitioner and the workman, within the meaning of Section 18 of the Industrial Disputes Act
Section
1947.
2P. Section 2P,
2P or 18?
18 is binding force. Read it 18. Read with 18. 2P, read with section 18.
Section 2P read with Section 18 of the Industrial Disputes Act 1947.
Well,
The parties therefore shall act on the same. Next. The award dated so and so, passed in reference court number so and so, in view of the settlement, stands satisfied.
On the other day, your lordship have a point that the amount is very low. So, our opinion was that it should be calculated as per the minimum wage of that period.
Then why do you sign it?
So, first, I
Can't do anything. I only said that you should have, then also you have signed it. What do I do?
further discussion was that they are agreeable to pay as per the rates of minimum wage.
You are not paying as per the minimum wages act. Huh? How many years? 1 year minimum wage is how
notification.
much?
2010 notification, minimum wage.
Yeah, we are disposing of the matter today. Why have we arrived at now?
No, it has been calculated on the basis of minimum wages.
Understood. Why are you going to 2010?
No, at that point of time, they were terminated in the year 2009.
They belong to what?
Unskilled worker.
They're semi-skilled worker.
All right, so this two.
Can't help it. You have signed it. Line 2 the amounts shall also be disbursed to the respective workmen or their legal representatives within 15 days from the date of the present order. I never thought this, you do this. These people should not have accepted this. Mr. Dasgupta, you should have
No,
Just upon
actually,
your
actually,
client.
they are entitled to gratuity also. They are entitled to gratuity, but when they are actually,
You are not paying their gratuity? Then we can take it out. I am not agreeing to this.
say no, gratuity calculate to dilia.
Are you paying the gratuity or not?
In addition to that, they are entitled to gratuity. It is
I
right.
will take it. This court also observes and directs that the above memorandum of settlement is only in respect to, is only in respect to the award dated so and so. In addition to that, the petitioners, the workman shall be entitled to the terminal benefits like gratuity and
That much.
the gratuity, which shall also be released to the workman within 15 days from the date of the present order.
This will be fair.
I'll just work it out properly. I'll put this line now.
Calculate को दिया.
What is this?
But here the petitioner has challenged the order dated 18/6/2024. But Lordship, there was a respondent number 1 has initiated a contract. And as per the terms of contract, my lord, the respondent number 2 and the petitioner, they have submitted the bill.
My senior likes in another book. Is coming.
My lord, I'll take your lordship to the impugn order, but for that kindly come to the condition of the tender, which provides, my lord, that specific condition lordship will find out
You are challenging which order?
18/6/24, that
Where is that?
82, page 82. my lord.
82.
Yes, sir. Annexure 21, page 82. But by this letter,
Payment again, release of machinery then yeah. This is reference to the above stated method. Your letter mentioned. Yes, why are you challenging this?
well, in fact, by this letter, they have forced us to pay the amount of the deposit, the amount of which BG was given. In fact, for releasing the BG. And in this letter, they said that there is an arbitration proceeding. There was an arbitration proceeding, and the proceeding was between the respondent number 1 and respondent number 2. It was settled. And because of the settlement, now we are required to
It's
pay.
not a settlement, it's an award.
That was that firstly, there was an award. After filing of the affidavit in opposition only, we came to know that the award was passed in 2020. In 2020, my lord, there was an award. They have now the annexed the award in the affidavit. Respondent number 1 is next. Otherwise, my lord, that has happened behind the back of the petitioner. And in fact,
So therefore, your claim as regards the amount, have you got the machineries?
we got the machineries in 2016.
Then
We got the machineries and my lord, they have imposed a condition on us that they will release the machineries subject to submission of the bank guarantee.
you kept the bank guarantee.
We gave the bank guarantee in
Have they invoked the bank guarantee?
no, they otherwise, my lord, this page 83, kindly see page 83, the last sentence. They said that they have given us, however, as they said, machineries already stand released to you by NTPC letter dated 2/2/2016. I'm reading second paragraph with the BG number so and so dated 6/6/2016 and the indemnity bond dated as security. You are hereby requested to deposit the amount of rupees 1,56,76,445. The valuation of the amount of the machinery when they were released by the NTPC.
15 crore, huh?
No, my lord, it's 1,56 lakhs.
15,676,000.
15,676,000 they have said. Within 7 days of this issue of lease letter, then my lord, they have given the bank details. Last paragraph, kindly see. It may also be noted that if the above mentioned payment is not made within the stipulated time by you, the same shall be recovered by encashing the bank guarantee dated so and so dated 6/2/2016. They have threatened us that you deposit the amount, otherwise we'll encash the bank guarantee. But ultimately we had to because it relates to the prospect of the.
You paid that amount.
We have deposited the amount. The next page. But the thing is not under protest. We had to deposit the amount. And kindly see the page.
But why have you not taken up with SPML?
But in fact, SPML is a party here. Respondent number 2 is a party here. We have served the notice. My lord, service report is there. They choose not.
No, you see the problem arose because SPML included within its claim your machineries.
But in fact, that was not known to us. And lordship, I'll take
I understand. It is not known to you. He has fraudulently done so. That SPML has fraudulently done so and taken the money from NTPC.
But what we are, my lord, lordship, we are proposing, my lord. We have placed before the lordship, lord, that since 2012 we are asking for the machineries. That these are our machineries. Please return us the machineries. But I'll take your lordship to documents are here. But it is known to the respondent number 1 NTPC that our machineries are lying there. In 2012 communications are there, we are requesting. In fact, they said that you do valuation of the machineries. We have at our cost, we have done the valuation. After the valuation, my lord, in fact, in 2016, they have given us a condition that you deposit the bank guarantee and take your machineries. We deposited the bank guarantee. Then, my lord, in our absence, behind our back, without any information, because all along in 2012, 13, 14, all along, we are in contact with the NTPC, but without any information.
But where you are subcontractor NTPC?
No, that is what, my lord, I am taking a lordship to page 30. Kindly come to the clause, my lord. In fact, the tender condition, there is a condition in the contract that the page number 29, my lord, page number 29, qualifying requirements 4.1.1. This is the contract they have in depth that, my lord, the bidder who wishes to participate in the bidding shall satisfactorily establish that he fulfills the qualifying requirements stipulated hereunder. The bidder should have executed the following work in construction of industrial and infrastructure project within the preceding 7 years of so and so. Then lordship may kindly see, my lord, the requirement is 3. Installation of 25,000 running meter of cast in situ board piles of minimum 600 mm dia in one of the so and so. So this qualification is, these are the requirement qualification. Then 4.1.2 provides that bidder who meets at least one of the requirement listed under clause 4.1.1 above at 1 or 2 A and B and taken together or 3 can also participate provided he associates with not more than 2 agencies of repute who should individually fully meet requirements of the balance relevant part under clause 4.1.1 above for which he is being associated and which the bidder himself is not able to meet. In such a case, bidder shall furnish along with the bid and undertaking jointly executed by him and
So
his
you
associate.
submitted an undertaking.
We have given an undertaking and
Where is that undertaking?
yes, Lord. In fact, if Lordship kindly permits the see the clause, my lord, for the work which I will do, my lord, that for that particular work, I have to deposit the 5% bank guarantee for the work. So although I am an associate with the respondent number 2 while submitting the bid, for my work, my lord, the bank guarantee for that work I have to submit. And the,
Understood, but the fact remains, you have a claim independent from SPML if they have to do machinery there.
yes, my lord. So kindly see the joint undertaking we have given page 31 and H3. So this is the joint undertaking we have given, and this is the part of the bid document submitted before the respondent number 1. Here, as per the clause, the second, please kindly see, whereas the owner invited bids for main plant, CW and offset civil works packages for Bongaigaon thermal power project, write its bidding document number so and so, and whereas the bid document stipulates that the bidder who meets the requirement at clause 4.1.3a through 4.1.3e of special conditions of contract SCC and at least any one requirement listed under clause 4.1.1 at 1 or 2a and 2b taken together, or 3 of SCC can also participate provided he associated with not more than 2 agencies of review who individually fully meets the requirement of the balance relevant parts under clause 4.1.1 of the SCC for which the associate is being associated and which the bidder himself is not able to meet. Then they said that SPML is submitted its proposal in response to the aforesaid invitation for bids by the owner bearing number so and so dated so and so for the main plant. And whereas SPML itself meets the requirement clause of 1.4.1.3a through 4.1.3e of SCC and at least any one requirement installed under clause 4.1.1 at 1 or 2a and 2b taken together, or 3. And in order to fully meet the balance relevant requirements of clause 4.1.1 of SCC, desires to associate with Mr. Meher Foundation, that is the petitioner, who individually fully meets the requirement of the balance relevant part of clause 4.1.1 at a or 2a and 2b taken together, or 3, or out of the balance part of the total qualifying requirement under clause 4.1.1 of SCC, and the bidder and the associate is required to jointly execute and furnish along with the bid an irrevocable deed of joint undertaking and be jointly and severally responsible and bound unto the owner for successful performance of the part of the contract for which the associate is associated for main plant, CW and offsite civil works packages.
Your claim is with the SPML.
But kindly,
Because the dispute have already been resolved.
but in fact, kindly see, Lord. So this is the undertaking given, and accordingly, kindly see, Lord.
No, but Mr. Nath, the problem arises that your claim is against the SPML.
Look,
how do you bring the NTPC out there? You see, the fact remains, whatever may be, SPML behind the back of yours did all these things.
Absolutely, and we are in contact with them. They never informed that we are.
Understood. So therefore, your cause of action is against not in NTPC. NTPC says, look here, these machineries were put out there. He has made the claim. We offered resistance, but then also arbitrator paid the amount, gave it, and we paid the amount.
But
So now the fact is, it is between you and SPML.
But kindly appreciate, but in 2000, since then, Malak, we are approaching them that you return us the amount. Malak, NTPC, at least they could have taken up it with before the arbitration proceeding. That
In
these
fact,
are
what they
the-
did, when you paid that amount, they sold that machineries to you. By that letter, what they did, they sold the machineries back to you, although not in paper.
that is what they are doing, but they cannot do because it is a duty incumbent upon them to at least inform the arbitrator or the whatever proceeding, because that was not known to us. At least they should have placed it before the authority.
Both of you joined together, you and SPML joined together, and to submit it out there, the bid out there, saying that, you see, I'm going to provide these machineries for SPML. And therefore, these machineries were there.
No, that is not the case. We are not providing any machinery to SPML because that particular work that is why the joint undertaking is there, that piling work, he doesn't have any qualification. For the particular work given to me for 13 crore, I have the responsibility to
No,
execute the
because,
work.
Mr. Nath, the problem with here is this code under 226 will be touching on the arbitrary level.
Malad, kindly appreciate the action on the part of the NTPC, why, how they acted, because in one hand, they know that this is my property lying with them. And they said that till the dispute is over, I will not allow. Finally, they said
So who had committed the fraud before the arbitrator?
the respondent number one, Malad.
Who?
But respondent number one.
NTPC?
Yes, Malad.
No.
No, it is a
Fraud
duty.
means they have suffered the award.
Malad, in fact, kindly see, Malad, they could have very well placed it that no, this much of amount we are not
They
allowing.
cannot claim. They could say, but who claimed?
Malad, it is,
The claim is being made
Malad,
by SPML.
Malad, we are not aware. We don't know.
No case.
No, Malad, kindly see, kindly appreciate, Malad, kindly see, Malad. Annexure 4, Malad. Malad, in 2012, page 55, kindly see. Well, these are our machineries lying with them.
Who is your senior?
Your Honor, Lordship is coming.
Who is your senior?
Mr. D. Goswami. Mr. D. Goswami.
D. Goswami.
Yes.
And who appears for SPML?
SPML services done, they chosen not to
They
appear.
will obviously not appear.
Look, ultimately, it's an arbitrary action on the part of respondent number one.
How can we impose upon them anything when they have already paid for those machinery?
Malad, how the respondent number can take a plea that no, we have already paid whatever is payable to you. We know that this is yours, but we have paid the amount to XYZ, the so and so. Don't claim to us. How they can act like that, Malad?
Because they have already suffered on the basis of those machineries.
Malad, our machineries, Malad.
Understood.
It is with them. Kindly see on 30/10/2012.
All understood their machinery. These were all your machineries understood.
Malad, in fact,
They didn't make the claim. The claim was made by SPML.
in fact, in 2012, after going through the affidavit in opposition, I have seen that in October 2014, the statement of claim was filed. In 2012, we have requested, page 55, kindly see, we have requested that our machineries are lying there. They stopped us to work because of failure on the part of the respondent number two. We said that please allow us to take back our crane, because those are our machineries. Ultimately, we are a firm. We have to work on that. And next, page 56, we have said that another work, NTPC work, we have to execute. Please release the machineries. After repeated approach, they said that okay, we will release the amount, we release the material. It was in first, it is in October 2012. Second, kindly see page 56. It is in the month of April 2014. We have again requested. We are again and again we are requesting them to release our machineries. After that, Malad, they in the year 2016 they informed us that get the valuation done for your machineries. Our machineries, Malad, valuation done at our cost. Subsequently, Malad, they release it by taking bank guarantee. So my humble submission is, Malad, NTPC has all the knowledge.
You say therefore the NTPC should pay you the value of your machineries,
My machineries,
which payment he has already made to SPM.
Malad, that is Malad. In fact, that is a plea taken by them, but we are not aware whether that has been done or not.
No, this
And-
is clear from their affidavit in opposition. Kindly see their statement of claim. Claim number 5. That is the machinery which is the question. This is
Malad-
what is appearing.
Malad, our machineries, it is known to them. It is within the NTPC. Malad, they could have very well said that see, the respondent petitioner, the Meher Foundation is already agitating that before us. Why should we pay you? Ultimately, because of the arbitrary illegal action on the part of the respondent number one, we suffered loss. for so long, and now they have forced us. Otherwise, they threatened us to
No, why
exercise the
on
bank
earth
guarantee.
did you make the payment?
Look, otherwise
Let
they
them
would.
invoke the bank. You could have very well challenged it.
But
Challenge the invocation of the bank guarantee. It's a case of fraud.
they
You
have
had the case out there. Why on earth did you make the payment and thereafter you are asking or filing a writ?
they have
Go
given us
there
they have
before the civil court.
they have given us 7 days time.
Huh?
They have given us 7 days time. They have given us
7 days is too
ultimatum.
long a period.
They have given us ultimatum.
7 days, most cases they invoke the bank guarantee and thereupon you come to learn. This is a very good, the NTPC is a very kind people.
Matlab, they have given us ultimatum of 7 days to invoke bank guarantee and matlab, to this is
Have you ever heard when you are submitting a irrevocable bank guarantee notice being given that 7 days we are giving it?
there has to be some reason for invoking bank guarantee. In the month of June,
Irrevocable bank guarantee was there. Irrevocable bank guarantee, you see, unconditional bank guarantees are there. See your bank guarantee. Where is your bank guarantee?
kindly appreciate, Lord.
Very difficult
There-
to appreciate.
There has to be some reason. Ultimately, suddenly in the month of June 24, matlab, they said that we are invoking the bank guarantee, otherwise you pay the amount.
Because they satisfied the award in 2024.
But it is
After having satisfied, you should have then also come to learn. Why were you sleeping all this while?
we are not. That is why, matlab, I have.
Where is your communication after 2014 when the statement of claim were filed?
Matlab, in fact, kindly see communications at page 55, 56. Kindly come for a moment. Page 55. Matlab. We have requested that in continuation of the above discussion between you and our MD over telephone, we hereby request you to release our service plan and arrange to make necessary outpass for the same. Then kindly see next page 56. This is our communication in April 2014. We have requested the NTPC Limited that once again approach.
Now nobody informed you about these proceedings.
No, my lord.
Show me the release order.
Release order, my lord. Kindly see, my lord. Page 58, kindly take a minute. Page 58, my lord. It is in the month of 1/9/2015, removal of machinery and equipment from site against bank guarantee. This is in reference to our letter dated 25/6/2015 regarding the valuation of machinery and equipment.
This is for evaluation.
Now, please, this is said.
Page 58 is for valuation.
Yes. Then, my lord, kindly, we have done the valuation.
Where is your release order?
I'm coming. Page 75.
Huh?
Page 75. Sir. On 2/2/2016, they said that this is in reference to our above mentioned subject and your later mentioned above. Based on your request for release of filing rigs against submission of security and security, the current valuation was done by an independent government approved valuer. Based on the report submitted by him, the residual value of the filing rig work out to be so and so. As on October 2015, in this regard, MS Meher is kindly requested to submit bank guarantee for the same value from a nationalized bank as per the attached format. MS Meher is also requested to submit an indemnity bond on a non-judicial stamp paper of appropriate value for the attached format. After submission of the bank guarantee and indemnity and after
Where is the
acceptance.
bank guarantee?
Bank guarantee, my lord. But bank guarantee, kindly lordship may take up the affidavit. In the affidavit they have next.
Have enclosed?
They have an explanation. Page number 356.
Page 360, 56.
356.
kindly read the bank guarantee 357, 358. Only as loss or damage, sale, so and so, caused to or suffered by, or that may be caused to or suffered by the owner by reason of the contractor failing to bring back to the site the said plant and machinery or any part thereof, or on account of any claim by SPML Infra Limited. And you see, this is the main word, or an account of a claim made by SPML Infra Limited, and to unconditionally pay the amount claimed. Now, SPML made the claim. So the bank guarantee has to be honored. Now, they gave you 7 days.
Lordship,
So fantastic. You should, therefore, you have rightly paid. Because it becomes a part. Therefore, your cause of action is against SPML
No.
for fraudulently asking the amount.
but in fact, the fraudulent action is on the part of both. The
Huh?
respondent, that fraudulent action is on the part of both, because the respondent number 1 and 2.
Not both.
But then,
He says that you are a contractor. Says, okay, I'm giving you the bank guarantee. You will give us a bank guarantee. Now see the condition of the bank guarantee. Condition is you are to return the plants and machineries.
Lordship,
And if you don't, the bank unconditionally says that he will make the payment of this 1 crore something. This is the condition. Now, this condition also includes if there is a claim made by SPML. So once the claim is made by the SPML and that SPML claim is being awarded, that in respect to these plants and machineries, then your bank guarantee should have been immediately invoked, which they gave you time.
but in fact, Lordship,
They should have asked for interest.
Lordship, kindly see, we are at the receiving end, my lord. Ultimate,
I know you are at the receiving end, but you are in the wrong forum.
look, whether the SPML can claim us, because when it is known to the
You
respondent,
therefore have to claim a book. Go ahead and bring it before SPML and file a suit against SPML that you have claimed this amount and therefore you are to pay me back.
but the respondent number 1 has a duty.
No, the duty is different, but the fraud is different. He has
But
committed a
respondent
fraud.
Respondent number 1, knowing fully
You
well,
may make the respond number 1 as a party in the suit. That's a different thing. But he may be at best a performer. But you don't have a cause of action directly against the respond number 1. You have a cause of action against SPML. And it is a private dispute.
well, in fact, we are against the action of the respondent number 1 in releasing.
I know why you are insisting on the respond number 1 because it's a writ court. Otherwise, you don't have a case.
But
very difficult, mister. I would have tried to help you, but this is a very difficult case. You cannot maintain this course. It becomes very difficult because at the end of the day, what happens? They are a public undertaking, public sector undertaking.
yes, yes.
This public sector undertaking could be now paying or would be for the goods for which they have made payment. That goods, they would not have a title over it or right over it because you have already taken it. So now what will happen? They are giving you the goods, on the other hand, paying SPLL for those goods.
Kindly see, kindly consider. Well, when the particular machineries worth rupees 1 crore 57 lakhs, we have already taken out. They
Why
can,
on earth did you mention this at page 358, that bank guarantee?
well,
Bank guarantee is against claims of SPML. This is, bank guarantee is made at your instance.
when it is known to them that we have already taken out the machineries that and the value of the machinery is 1 crore 56 lakhs. At the time of settlement, well, without any prejudice, I'm submitting that at the time of settlement, they can very well say that deduct 1 crore 56 lakh because this has already been taken out.
Mr. Nath, they
Why, Malad?
should have said, they should not have said, but the fact remains the SPML had committed a fraud
Look,
by
why?
making applicant. Whether they have said or not, that is a different thing. There is an award. This court would be now touching the award by way of a writ proceedings.
Well,
This is too far-fetched,
My-
very difficult.
my responsible submission will.
My,
will-
I
it will
think
not- it
my,
will not-
my limited ideas do not
Well, my,
foresee a good result. You may try your luck next week or next to next week. There might be better judges who may understand your problem.
no, no, I'm-
But it is very difficult for my limited experience and limited acumen to comprehend this to be a matter coming under 226.
not my,
Very difficult.
my. responsible
This is a
submission-
matter for Monday, Wednesday, and Friday, not for Tuesday and here. Should be dismissed on that day. Motion somebody had issued notice, they were kind enough.
No,
Let me
no,
go before that judge.
no, no, kindly
Very
appreciate,
difficult.
kindly appreciate, no. They could have, instead of,
Very difficult.
instead of making payment, they could have very well say that,
Ah.
this particular,
He may issue, he may give you, he has issued this.
well, when that particular machinery has been taken out, it is not with them. They could have very well say that this is not with us. Why should we pay you? They can very well say
Because they had a bank guarantee. You see,
Malad,
you therefore understand.
Malad,
You see, what was the terms of the bank guarantee? What was the ground? Why you were said that the bank guarantee has been issued? The bank guarantee is issued that it is as if the goods have been given to you as a jimma and giving it to you with a promise that you will return back to him. That is why it is being mentioned, bank guarantee.
kindly see, Malad, the respondent number 1 can very well.
Let us
protect
see
the-
your indemnity now.
Lord,
What do you say in the indemnity? Okay, bank guarantee, somebody else writes it indemnity. 361.
Lord,
Kindly see. Hereby, page 362, hereby undertakes to indemnify and keep the owner indemnified for the full value of the said machineries as per the submitted bank guarantee. That in consideration of the mayor to be released by the owner, the contractor hereby under the release area shall not be sold, mortgaged, or misapplied in any manner. And consideration of the remand area would be returned back to the owner by the year before release of the submitted bank guarantee. That means this is your undertaking.
yes,
Then you are going to return it.
Malad, third,
You are
kindly,
going to return this there. This is your indemnity. I think dismiss with cause.
Malad, 13, clause 13, kindly
We
see.
have spoiled half an hour
No, Malad,
in a
I'm,
matter of
no,
this.
Malad, I'm raising my
Or are
hand.
you
because-
trying to ask me what solution you should have?
But-
It's a very difficult case, Mr. Nath, very difficult to do it under 226.
Malad, they can very well protect our rights. Malad.
No,
They
it
can very
cannot
well
because of
protect-
your indemnity. Your
Because-
indemnity is, you see, your bank guarantee and indemnity spoils your entire case. So the thing is, SPML has become defunct.
No, no.
They're there.
SPML, yes, SPML is there.
Your client,
No, no, not my,
not in this case, otherwise.
no, no, not my client, not my client, but my client has informed that they are still functioning. They are running. My client has the knowledge, they have a office in Kolkata, they have the knowledge.
Do you have an arbitration agreement with SPM?
That my lord, I have to find out.
And they have satisfied it. The problem lies there. You could have made the claim in the execution proceedings.
My lord, in fact, on the 73, they have entered into a settlement. The award is of 2020, settlement came in 2024.
The reason
But-
must be
but-
there. They must have gone for execution.
But we are not
You were
aware.
not, but
We're not
if you
aware.
could have known it.
So, my lord, see, so my lord, the respondent number 1, it is a duty incumbent upon them to protect the interest.
a duty may be there for not informing, but you have given an undertaking that these goods we will return it.
Well, in fact, the letter says that this is the format, you give us undertaking in
That is different. You are not challenging,
indemnity.
Mr. Nath, you are not challenging the indemnity.
No, we are
Difficult.
not, we are not challenging. We are not.
You are not
that. In fact-
challenging the bank guarantee.
In
Difficult.
fact, the situation is like that, Malad, in 2009, the contract entered and till
The judge who
2016.
issued the notice nowadays, since in the division bench, he doesn't take bench for. Otherwise, who will dispose it of in your favor? Difficult.
No, Malad,
Very difficult. Very
whether
difficult.
I am hesitating my grievance. It is up to your lordship, Malad, ultimately decide the matter.
Very difficult. Yeah.
Lordship may grant me some opportunity, Malad, on the day after tomorrow. I'll just try to Malad, see.
Not day after tomorrow. Let's have these matters after that. You are early. You are going back.
No.
Yeah.
Today
So
I'm
let
there.
us have it some 2 o'clock. Some matters are there after
Yes,
that.
Yes.
In the meantime, while dictating other matters, I may have some idea. Let's see. I want to help you out. I know that you have been put into trouble, but the fact remains, Mr. Nath, that this court problem is that your claim is actually with SPML. He had committed the fraud, and thereby the problem is for this court to direct them. There is no problem. I can very well direct them. It would be a 2-minute job for the appellate court to interfere. You don't like your judgments to be interfered just for the sake of it in 1 minute. How this court, single judge passes these orders, the division bench will say. So better off, this is a very difficult thing to do it. Unless there is some novation of a contract or anything you can show. Your bank guarantee and indemnity is very damaging. More particularly at page 358 and the indemnity, very damaging. Means you are taking it as a jimma with a right to return it.
For years together, it is lying with them.
Understood, but you have taken it in this manner, which
the-
means it is subject to the outcome of any claims by SPML. Now, SPML has made the claim. Problem lies in the SPML did not inform you behind the back, he put your machineries out. So therefore, your claim is qua SPML that this has happened. So therefore, you have to go there and ask SPML about it. Anyways, let me think.
What has happened here? They have taken the amount from us and given it to SPML when they know that machineries belong to us. That is the action on the part of the customer number one. Well, can I pray for taking up it on Thursday, Malad, so that I can also talk to my client? They are from Kolkata, Malad.
Thursday. Thursday, how many matters are there? See, the problem lies there. We are in the month of May. Thursday. No, not possible. Okay, let it be next
Tomorrow.
Tuesday.
Tomorrow.
Tomorrow, you know how many matters are there. You see, very difficult to do. Tomorrow, not possible. Huh? 70. 17 matters. And day after is 16 matters. Then we have that infrastructure bench. Then day after 22 matters. As of now.
I'll just have a talk to my client. Malad.
Okay, let's try our luck tomorrow. After 2. Let's see if anything can work. Otherwise, this is actually a Wednesday matter.
No, I have to.
List the matter on Wednesday
26th of
Tomorrow.
January, please.
at 2.
In the court of Honorable Chief Justice, my lord. So I have taken time that I have to argue this matter. I'll let it be taken up, my lord. 11.
Item 11.
11. My lord, item number 11, my lord, here with regard to that taking over land. That is
No, why I asked you to appear in this matter, taking into account. You see, the fact remains out here that you have taken over the possession of the place.
I have not taken. BTC was
Well,
not in existence. my
I
lord.
don't know how you
Yes,
take
yeah,
it.
yeah.
Now you are the you control the revenue. You have to take it up with the revenue department. How you make the payment of what, or water resource department. But the fact remains that there is an interest component
Yes,
which is very high.
yes.
So therefore, I was saying that if it can be mediated as
Yeah.
regards that amount, he has agreed to the double the amount, what amount he has received, the amount, that amount can be, that would suffice. I think it is a very reasonable demand, taking into account, otherwise if we imply 9% and 15%, it would be very high.
Very high.
So
Absolutely.
therefore, if you can mediate that aspect of the matter, and then things would improve.
Fine.
So you take it up with the authorities concerned that
Yeah.
this is the view of the court. Otherwise, if I have to pass the order and taking into account your admissions, it becomes very difficult that he will be entitled to interest at 9% from 2001
Yes.
to, and
27/5, 2001.
27/5/2001 to 26/5/2002, 9%, and from there
15%.
15% till 2026, it will be a colossal amount.
Absolutely.
So take it up with your department and
And the state, my lord, has to look into it because 2001 amendment, we have
Madam-
come into existence.
Madam, you are there in the water resource department. Whatever may be the projectives of the water resource department. So therefore, your department also has to take care of this, how you are, because at the time BTC was not
Not in
formed.
existence, man.
So therefore, it was taken by the water resource department at that point of time. So the water resource department shall talk up with your department and with the
Yes.
PTC and come to a figure of this 22,50,000, which was the amount. And if you can come to that, it would be a better thing. If I pass an order, it would become
Mine,
more.
absolutely.
This court have heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, as well as have also heard Mr. A.K. Bhuya, the learned senior counsel, as well as the standing counsel of the BTC, senior standing counsel of the BTC, assisted by Ms. N. Chaudhary. Additionally, this court have also heard Ms. P. Chakraborty, the learned counsel appearing on behalf of the Water Source Department. Taking into account the issue involved, this court have suggested the learned counsels appearing on behalf of the BTC as well as the Water Resource Department that they should take up the matter with the officials so that an amicable settlement can be reached in the instant proceedings. The learned counsels appearing on behalf of the respective departments submits before this court that they would take it up with the officials and place their views on the next date. List this matter again on 3rd of August 2026 for further hearing of the matter.
Deeply obvious. At 2, my lord. At 2.
3rd of August, we'll see what happens at 2. Why do you need it at 2?
Lordship, hardly matter at length there.
A further hearing to decide. No more further hearing. It's the matter before any other court.
No.
You would not get that amount also.
No. Yes, careful.
Yes, Mr. Who is appearing in this matter? Item 1. Yes.
Lakshmi, today they have filed a affidavit, your lordship, from the side of the respondent number 2. They are discussing the matter, your lordship, and they need 2 weeks, 2 months time.
Water resource is vacated it. Irrigation is still holding on to it. You have any document pertaining to acquisition? No.
That is why also we need some time, the whole matter pertaining to state of world. As far as the file by the deputy commissioner lawsuit, the case belongs to anything available.
Khadi board is not there.
FPDCL and Khadi board is there.
APDCL is also
Official
there.
office is also there, part of.
You're also there. What right you have over the land? Somebody has asked you to remain there. Obviously, you have not acquired anything. You are a company. You have taken over from ACB. So obviously, at the time when you have taken over, whether any right have been transferred on the basis of that land, you will have that document. You are not a very old company. Then this is 2 months is too less. It's too, we can't look into this in this matter of 2022, 4 years have already gone by, and this is what you come up with when there is no records available and there is nothing to it that you are going to acquire it.
1 month time may be granted.
And what about the other aspect which I have stated, that if we are taking into account the response has been whether they are contemplating payment for compensation for use and occupation of the land.
That is not reflected in the minutes because, my lord, all the departments are trying to trace out that record on the basis of which any release amount has been made in earlier, so that we need some time to.
You have not paid a single penny to them.
No record is available, my lord, till now.
No. Have you got any penny, any money?
Lordship, not at all, your lordship. Forcibly, they took the position, your lordship, forcibly.
See, forcibly.
Without following any procedure of law.
No procedure of law.
At that time, it was lying vacant, that's why, your lordship, they have taken that way.
And get hold of those persons of more importance rather than these people. You can't bring before this court a minutes before the additional deputy commissioner, district commissioner, and give it to before this court.
That progress.
It has to be of a level of this particular, it has to be, the district commissioner has to be there. The chief engineer has to be there. Then what is all these people are there? These minutes deserve no consequence. Pursuant to the order passed by this court on 6/4/2026, an affidavit has been filed on behalf of the District Commissioner, Kamrup Metro, through the Additional District Commissioner, Kamrup Metro, on 19th of May 2026. From a perusal of the said affidavit, it is seen that a minutes have been recorded among some certain officials, wherein they seek for 2 months' time for obtaining, for tracing out necessary documents, taking into account that a possession have been taken by the very respective departments around 66 years back. The affidavit, however, does not take care of, does not deal with the questions posed by this court by the order dated 6/4/2026. Be that as it may, taking into account the said affidavit, this court grants a final opportunity to the respondent departments to place the necessary materials in pursuance to the order dated 6/4/2026 on the next date without fail. It is observed that if on the next date such documents are not produced, any documents as mentioned in the minutes of the meeting, or the instructions are not placed in pursuance to the order dated 6/4/2026, this court shall proceed with the disposal of the writ petition on the basis of the records which are already available. List this matter again on 4th of August 2026 at 2 p.m. Heard Mr. M.K. Das.
My lordship.
The learned counsel appearing on behalf of the petitioner, Mr. M. Sharma, appears on behalf of the respondent numbers 1, 2, and 3. Mr. So-and-so appears for respondent number, is it 4 and 5?
My lordship.
Appears on behalf of the Circle Officer Sipaza Revenue Circle, as well as for the Senior Sub-Register among all the preface. The present petition has been filed by the petitioner being aggrieved by the actions on the part of the respondent numbers 1, 2, and 3, being aggrieved by the email dated 5/11/2023, issued by the respondent numbers 1, 2, and 3, respondent number 3, whereby the candidature of the petitioner for the regular/rural retail outlet petroleum dealership in area Khondajan Model High School to Moroi Bijulibari Government High School on NH 15 in the district of Darang was rejected as a Group 1 candidate. Isn't it? Next. The brief facts which led to the filing of the present writ petition, brief facts are that an advertisement was issued on 28/6/2023 by the respondent number 2 regarding appointment of regular/rural outlet petrol pump dealership at various locations in the state of Assam. In the said advertisement, it was provided that the application for retail/rural outlet dealership along with online payment of non-refundable application fees should be submitted online by 27/9/2023. The petitioner was interested in the retail dealership, outlet dealership for the location, namely Khondazan Model High School to Moroi Bijuli Government High School on NH 15 in the district of Dorong. The petitioner having entered into a registered lease deed dated 22
My lordship.
9 23 or 22
23.
23/9/2023
No, the date is 22/9/2023.
22/9/2023 have entered into a registered lease deed with where is the lease deed?
Lord. Page number 126.
Have entered in a registered lease deed on 22/9/2023 with Mr. Brozen Deka and Sri Bhababindra Deka, BHABINDRA, Deka, in respect to a plot of land at measuring 1 bigha covered by Dag number 1045 of periodic Patta number 370 located at village Bijulibari under Moza Lokrai in the district of Sipazar Revenue Circle. Lokrai, under Moza Lokrai within Sipazar Revenue Circle in the districts of Dorong, Assam. Subsequent thereto, the petitioner submitted the application on
24/9/2023.
24/9/2023. Where is that?
That is at 152.
Page
my lord.
111.
Page
152 and 111.
152.
Petitioner's application.
Application on where? Ah. Where?
111, my lord.
Application on.
Transaction
Is
date.
this the entire application? No.
Transaction date and time, my lord, 24/9/2023.
Where is the entire application?
My lord,
You have not given the entire application.
Lord, 152, my lord.
One?
152, page 152, my lord, part of the additional affidavit in opposition.
Submitted an application on 24/9/2023.
My lord.
Wherein, on the basis of the registered lease deed dated 22/9/2023, the petitioner applied as a Group 1 candidate. Full stop. At this stage, it is pertinent to take note of that while making the application through the online mode, the petitioner submitted a lease deed, submitted the lease deed with lease deed, had uploaded the lease deed dated 22/9/2023, wherein with an incorrect page 3. Wherein, full stop. The said page 3 of the lease deed dated 22/9/2023 stipulated that the period of lease shall commence with effect from 1/10/2023.
1/4,
1/4/2024.
23, 24.
24.
The next year, my lord.
Full stop. Taking into account that the petitioner applied as a Group 1 candidate and he was the sole candidate,
My lord.
the petitioner was asked to deposit the secured deposit, what is that? 50,000 is what? Security deposit.
It should be ideally initial security deposit. It's called.
Was asked to deposit the initial security
Security
deposit of rupees 50,000
My lord.
by the communication dated
By communication, my lord, dated 19/10/2023.
19/10/2023.
My lord.
Thereupon, by another communication dated verification na?
My lord.
Submission of documents 19/10/2023.
By the same date.
Yes,
No.
my lord.
No, pursuant to my lord 5/11/2023, where the candidature was rejected.
No. Document and, my lord, the amount security deposit on the same date, my lord, 19/10/2023.
Where is that document?
Page 116, email, my lord.
Yes.
19/10/2023, the petitioner was informed. The records further revealed that by the email dated 19/10/2023, the petitioner was informed that as the petitioner was the loan applicant, loan eligible applicant in the location under Group 1, the petitioner was provisionally selected. It was further mentioned that the said intimation was a preliminary intimation towards the petitioner's provisional selection for the retail outlet dealership. However, the award of the dealership was subject to compliance of the terms and conditions of the corporation in that regard. Further to that, on the same date, by another communication dated 19/10/2023, the petitioner was asked to remit online rupees 50,000 towards initial security deposit and upload the set of self-attested documents as specified in the said communication. So that the application for award of the retail outlet dealership could be processed. The documents which were referred to in the said communication dated 19/10/2023 entirely included the copy of the land document in support of ownership of the lease rights. It was also informed that verification of all self-attested photocopies shall be done with the original documents during field verification of the credentials. Pursuant thereto, the petitioner uploaded the various documents in terms with the communication dated 19/10/2023. Justo. Subsequent thereto, on 5/11/2023, the petitioner was informed by an email that the candidature of the petitioner have not been found eligible for retail outlet dealership on the basis of the documents submitted by the petitioner. Justo. The reasons were also assigned to the effect that the clause 1 of the lease deeds stipulated the commencement of the period of lease from 1/4/2024, which is the date of future, which meant that the applicant had no rights, ownership rights on the land on the date of the application, and hence was found not eligible. The petitioner thereupon submitted a representation on 8th of November 2023, stating inter alia that the lease deed dated 22/9/2000, registered lease deed dated 22/9/2023, the commenced from 22/9/23 and not from 1st of April 2024. It was further mentioned that initially in the agreement, it was mentioned as 1st of April 2024. But at the time of registration, the said aspect was corrected and put as 22nd of September 2023. The said aspect having not been considered, the petitioner approached this court by filing the present petition on 1/12/2023. The record reveals that this court, by an order dated 4/12/2023, issued notice and passed a limited interim order that though the draw of lots may not be put to hold, but no final decision be taken for allotment of the petrol pump in question till the returnable date. The interim order thereupon have been extended from time to time. The record reveals that an affidavit in opposition has been filed by the respondents. Respondent number
2 and 3, my lord. 1 and 2. 1 and 2. 3. 3 to apply, yeah.
Page,
Five circle
your
officer.
affidavit starts at page.
It starts at page 142, my lord.
142. 1, 2, and 3. The sub-register file.
Respondent numbers 1, 2, and 3. On 12th of June 2024, wherein the decision to reject the petitioner's candidature as a Group 1 candidate was justified. It was mentioned that the petitioner submitted the application online on 24/9/2023. It was stated, upon scrutiny of the registered lease deed, which was uploaded by the petitioner, it was seen that the deed was registered before the senior sub-register Mongoldoi on 22/9/2023, that is before the date of submission of the application. However, in serial number 1 of the deed at page 2, it was stated that the lease deed would commence from first day of April 2024 for a period of 20 years. That is 5 plus 5 plus 5 plus 5 plus 5 years. And after the completion of the lease period, lessor can continue the lease with mutual consent of both the parties. It was further mentioned that though the lease deed was registered on 22/9/2023, that is before the date of submission of the application, the lease rights would only commence with effect from 1/4/2024, that is on a future date, which means that on the date of submission of the application, the petitioner was not having ownership of long-term lease rights over the offered plot of land. It was further mentioned that one of the essential eligibility criteria in the dealership selection brochure is that the applicant either has ownership of registered long-term lease for a period of 19 years, 11 months as on the date of the application. So further to that, it was mentioned that as the petitioner did not have a registered long-term lease as on the date of the application, therefore the petitioner's application did not fall under Group 1 category. First, this court also finds it relevant to take note of an affidavit filed by the respondent number 5, who was the senior sub-register Dorong.
One 43 page.
Age?
143.
143.
Para 4.
Para 4.
No, before that. He's not that. These pages, whatever they have put is all different. Filed by respondent number 5, that is the senior sub-register, Mongoldoi, on 19th of January 2024. From a perusal of the said affidavit, it is seen that on 22/9/2024-23, it is mentioned in the said affidavit, the senior sub-register Mongoldoi have stated that on 22/9/2023, a registered lease deed was executed in his office on the strength of a no objection certificate issued by the ADC Revenue by the NOC dated 21/9/2023. And in the said lease deed, Hovindra Deka and Rosen Deka were the first parties, lessors, and the petitioner was the second party. It was also found that the NOC and the requisite stamp paper and registration fees were duly paid as per the Act and the rules. The said lease deed, authenticated lease deed, which was registered before the senior sub-register Mohaldoy, was enclosed as Annexure B to the said affidavit in opposition filed by the respondent number 5. A perusal of the said authenticated lease deed dated 22/9/2023 reveals at page number 2 at serial number 1 that the lease deed would commence from today, that is, mentioned that the lease deed would commence from 22nd of September 2023 for a period of 20 years. Serial number 1 of the lease authenticated lease deed dated 22/9/2023 being relevant is reproduced hereunder. You have page 150. The petitioner had also filed an additional affidavit was also filed by the respondent numbers 1, 2, and 3 on 18th of February 2026. Whereby the lease deed which was uploaded by the petitioner was enclosed to the said additional affidavit. A perusal of the uploaded lease deed by the petitioner as enclosed to the additional affidavit, and more particularly at serial number 1, shows that the lease deed would commence from 1st day of April 2024. First off, this court have duly heard the learned counsels. First off, the instant petition was listed before this court on 13/5/2026. On the same day, this court directed the petitioner to produce the original of the lease deed, registered lease deed dated 22/9/2023. First, on 18/5/2026. First, on 18/5/2026, the learned counsel appearing on behalf of the petitioner had produced the original lease deed, which have been original lease deed, registered lease deed dated 22/9/2023. From a perusal of the said original lease deed, it is seen that the clause at serial number 1 of the lease deed stipulates that the lease would commence from 22/9/2023. First, This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. The learned counsel appearing on behalf of the petitioner submitted that it was a mistake on the part of the advocate in uploading the incorrect a discarded page, the discarded page number 2 of the lease deed.
Not advocate, my lord. I myself has done, my lord.
You are the advocate.
No, not the advocate, my lord. The petitioner said he inadvertently uploaded.
Inadvertently uploaded the discarded page. The petitioner inadvertently uploaded the discarded page number 2 of the lease deed, which without full stop. The learned counsel submits that in actuality, the registered lease deed, as would be seen from the materials on record as well as the original document, would show that the lease commenced from 22/9/2023 prior to the submission of the bid
My lord.
by the petitioner. He also referred to clause 4 Roman 6 B, isn't it? Of the brochure for selection of dealers for regular and rural retail outlets of the Indian Oil Corporation, wherein it is mentioned that the provisionally selected candidate would be provided 21 days time from the date of intimation through SMS/email to make suitable amendments/addendum to the lease agreement and submit the same to the concerned OMC. He further submitted that the basis on which the rejection of the petitioner's application as a Group 1 candidate was not there, inasmuch as the lease deed in question, the registered lease deed in question dated 22/9/2023, categorically mentioned that the lease would commence on 22/9/2023 itself. Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 1, 2, and 3, submitted that certain aspects are not rectifiable. In that regard, he referred to clause 23 of the 23 of the brochure, wherein the list of non-rectifiable deficiencies in the application have been mentioned. He further emphasized on subclauses G and G and
G, my lord.
G.
G.
Only G.
Only G. And 55, page number 55, clause 23, read with page 28. Page 28. That rectification in terms of land.
Hmm?
28, my lord, the third paragraph. That the rectification of a lease agreement could only be in pursuance to an aspect of subletting, my lord, not any other deficiency. That was the ground I've taken, my lord.
He referred to subclause, and in that regard, he has specifically referred to subclause G, which stipulates that group of land as declared by the applicant in the application cannot be rectified. The learned counsel for the respondent numbers 1, 2, and 3 further referring to the clause 4 Roman 6b, further referring to the second part of 4 Roman 6b, submitted that the provisionally selected candidate would be provided 21 days from the date of intimation through SMS or email to make suitable amendment or addendum to the lease agreement. Only in a case where the lease agreement for the land offered by the provisionally selected candidate did not have a provision of sublease. That's it. Good stop. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record, including the original lease deed dated 22/9/2023. Further to that, this court have also perused a perusal of the impugned order dated very dead.
5/11/23, page 136.
Dated 5/11/2023 shows that the rejection of the petitioner's lease deed, rejection of the petitioner's candidate as a Group 1 candidate was on account of clause number 1 of the lease deed, stipulating that the commencement of the lease to be with effect from 1st of April 2024. The reason why and the reason for doing so is on account of the fact that as on the date of submission of the application by the petitioner, the petitioner did not have a long-term lease of 19 years, 11 months. However, from a perusal of the materials on record, including the affidavit filed by the respondent number 5 and the original lease deed dated, registered lease deed dated 22/9/2023, would show that the period of lease would commence from the date of the execution and registration of the lease deed, that is on 22/9/2023. Under such circumstances, it is therefore the opinion of this court that the rejection, it is the opinion of this court that the that the defect in question which the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 had submitted to be non-rectifiable is misconceived, inasmuch as the original document categorically mentioned that the release date, the lease would commence from 22/9/2023. This court also finds it very pertinent to mention that in the list of non-rectifiable deficiencies in the application, which is mentioned at clause number 23, there is no mention that a wrongly uploaded document would result in rejection. Rather, a perusal of the brochure would show that in spite of documents being submitted, uploaded, there would be a mandatory verification of the original document. And if the original document is not placed, during scrutiny, within the stipulated time, the application would be rejected. Under such circumstances, it is therefore the opinion of this court that the defect in uploading the wrong page in the original, in respect to the registered lease deed dated 22/9/2023, which being an inadvertent error, was a curable defect and And as such, the respondent numbers 1, 2, and 3 ought to have considered the said aspect when the representation was duly submitted by the petitioner. Considering the above, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned rejection of the petitioner's candidature as a Group 1 candidate by the email dated 5/11/2023 stands set aside and quashed. Number 2, the respondents therefore, the respondents numbers 1, 2, and 3 are therefore directed to proceed with the evaluation of the petitioner's bid by taking into account the original registered lease deed dated 22/9/2023. That's all. I can't give you anything more.
My lord, I had also submitted a copy of your lordship's order in Ruhul Amin Khan against IOCL.
What is that?
Paragraph 17, 18, and 19. The facts are slightly different, my lord, but the principles are same, my lord. 17, 18, and 19. Same issue. There, that matter was not allowed but your lordship had noted
If
down.
the offered land is on long term, there are monthly, then the lease should be. Therefore, this is by D.K. Sharma was there, na? You oil company councils keeps on changing, na? Sometimes you become you do for against BPL.
As of now, I've not done
You
that.
have not
but
done.
if I-
Other people keep on doing. Mr. P. Bharadwaj does it. Then this one, in many here, D.K. Sharma is appearing.
The retail side, my lord, there are few, there are retail.
In this
side.
age, there is another judgment where he is appearing for the petitioner.
Maybe
I have
against,
to pass on. And I think this is the only judgment I'm allowing.
and I'm grateful, my lord.
Deeply obliged.
There shall be no order as to cost.
My lord, they have filed the affidavit very belatedly, my lord. They filed it, copy was given to us on Saturday. So we'll require 2-3 days time, my lord.
Okay.
My lord, there is some urgency also. Can it be on second, my lord?
Okay. You have other two, 3 matters of this? No, only one.
No, I think one is closed, na? No positive. Duita pending. Pending, sir.
You are suspended.
Suspended. Based on some, my lord, LS complaint, but no copy, nothing has been
No, in the
given.
affidavit we have annexed. In the affidavit, one of the materials we have annexed.
But we have not been, now we have given, where have we given earlier?
No, show cause has been issued already. They have been given the show cause.
You have issued the so-called proceedings against him.
Yes. Show cause has been issued.
How much time would it take to complete?
My lord,
এখন কোনে কাক দিছে? ও বুঝিছো মানে anyway, how do I reply?
Not legible?
No, my lord, please have a look at page 70 of their affidavit, my lord.
it's a type copy.
Page 70.
Yes,
Ah,
origin is not, this is the complaint.
Huh?
Who has given to whom, what is the date?
sir. These are complaints.
These are complaints.
Yes. Page 72 is the vernacular, the original copy, 71 is the type copy.
No, of this there is no original copy. Say of 70 there is no original copy. Anyway, we'll deal with it, my lord.
In any case, my lord, these complaints, lordship is not going to decide the merits of this complaint. Ultimately, the show cause has been given to them. They are going to reply to the respond to the show cause notice. Here they are before lordship challenging the suspension. And lordship is examining whether we can suspend it or not. As per the provisions of the particular order, suspension can be done. Now the
Suspension power is there. We are not denying that you don't have the power of suspension.
So the basis for suspension we have annexed in the affidavit that these are the complaints. Now we have given the show cause notice to them. They will respond and accordingly that process will go on. So
Anyway, my lord, we'll file a reply. Instead, actually, they have given us the copy on Saturday. So, my lord, we have to ascertain also who are these people, whether they are our consumers. We'll file the affidavit, my lord. We pray the matter may come up on 2nd, na? 2nd June.
Okay. Mr. Kane Chaudhary, Delaware Senior Counsel, appearing on behalf, assisted by so-and-so, appearing on behalf of the petitioner, submits that the petitioner would like to file a reply to the affidavit in opposition filed by respondent numbers 1 to 3. Full stop. He submits that the matter requires, not second, why? On third. List this matter again on 3rd of June 2026. Full stop. Affidavit in reply be filed on or before 1st of June 2026. very good. Oh, this one.
My lord, before I proceed, whether the original records are there? Huh? My lord, what had happened, Sonari Tea Company, my lord, within their land there is a pond, the big pond. Now, my lord, some people claim that it should be used for historical purposes only. So it should be in the revenue record, it should be treated as a place of historical importance. Now, my lord, there is no dispute that this pond is comprised within our patta land, tea patta, tea periodic patta land. Now, my lord, what they have done, they have undertaken an proceeding. Based on the proceedings, my lord, they have said that my periodic patta status, tea periodic patta status should not be there. Now it will be treated as an historical pond. Now, while doing so, my lord, they have done it ex parte. And a date was fixed on 24th, a particular date was fixed. But on 24th, my lord, the presiding officer.
Where is the document?
Yes,
Impugn order.
yes. If your lordship would kindly come to page number 35 onwards, my lord. Now, if your lordship would kindly come to page 36.
Yes.
Now, please come to the date 24/3/15. Opposite party learned advocate submitted attendance, but hearing could not taken due to engagement of the undersigned otherwise. That means presiding officer is an executive magistrate. So maybe he had some other, my lord. Next date 27/3/15. When 27/3, my lord, 15, the OP is absent. I was not even intimated. How do I know, my lord? Let from the records it is be shown that I was intimated that the next date is 27th. You acquire this land if you want to make it historical pond. এই ফটোবিলাক ক'ত আছে?
116 is different.
116, my lord.
116 is
Yeah,
different.
different purpose.
116 is tomorrow, you see, for purpose of mutation, you require two things. One is possession and one is title.
Yes.
Sometimes if you don't have possession over there, then they strike out their name. This is what
That
it
is the one.
But mutation does not confer a title. Mutation does not confer or create or extinguish the
Yes.
title.
But
Therefore,
mutation
if you want
presupposes
to cancel the
possession.
patta or remove that patta out from there, either you acquire or cancel the patta.
Yes.
But you can't strike out on the 160.
That is true. But one
You take action under 26.
26 is now no longer available because 26 cannot be resorted to because the office of the commissioner is defunct now.
So then obviously then you have to do something else.
So they can acquire the land. If they wanted to preserve it as a historical pond.
Cancel the patta in respect to that or bifurcate the patta and take it out.
Now,
Do whatever you feel like. But 116 is limited to the only striking of the net. The fact that you are only to look into it as to whether they are in possession.
Yes.
possession is not because
So if they are not in possession, you may strike out the name from the record of rights. But you cannot take out cancel the patta and make it sarkari.
no,
Very difficult.
my respectful submission would be there are two aspects of the matter. Very quickly, I will submit.
these proceedings that were drawn up under 116 is a fallout of an earlier proceeding before this honorable court. Where
Let us
this
that again
honorable-
was an expert. Let us not go into that. It would means why do you compel this court to say something?
Now, my lord, if I may respectfully submit,
You put this court into embarrassing position.
now, if I may respectfully submit, now, striking out the name, if that is done, he is no longer a pattada in respect of that plot of land. Because his name is struck off. If there can-
No, it is, this is a striking out, you can't make it sorkari. No, impossible.
no,
You-
sorry.
You can make it, that is the mistake, and I think I've passed around for three,
Yes,
four
yes, one
judgments
that
on this.
multi company,
One is, yes, what Mr. B. Doctor did it. Pascal,
yes,
yeah.
we have that.
What is the name?
That is it.
Is it reported
Uh,
judgment?
Mount Company, TN Seeds.
Ah, This is a concept is different. That is the, maybe a lot of people do. Now, otherwise, if we go what you are doing it, let us assume today, you are not in a plot of land. Somebody encroaches your land. Obviously, you are not in possession.
So,
So are you going to cancel the petition? If we apply the law as it is, then it becomes Sagari.
Then it may cause prejudice for.
The reason behind is, why do you need a mutation? Mutation is for revenue entry.
basically
Revenue
for
for
revenue.
collection of revenue. So therefore, if you are not enjoying the possession, so therefore you are not required to pay. That is the basic idea. We go as per the 1962 judgment of the Supreme Court. It says, therefore it says, it is only yes, Moth Tea Company, yes. And this is being followed by another judgment of Justice Ansari.
Yes, Justice Ansari's judgment was
Very
the first in
difficult,
line, my
very
lord.
difficult, You thus, it is clear that Segra would be applicable only when a person who is the proprietor so and so and abandons his interest as the proprietor over such interest here. So therefore, you apply the doctrine here. Here he says about the doctrine of a seat. I think 300 now.
308. Capital.
300A. Yeah, doctrine of a seat.
Because
If a
Justice
person
Ansari's
goes away. But
judgment-
this is not the question of doctrine of a seat where nobody is found. But there was one company which was there. I still remember where the doctrine of a seat was applied. I was on the one side, and the other side was Justice N. Chaudhary expired. So he was applying. Then I learned, okay, what is the doctrine of a seat? It's a very interesting doctrine.
Now here, my lord, Honorable Justice Ansari's decision is the first in line. So far as 116 is concerned. Because if we make a search, my lord, we will find that his judgment, his lordship's judgment was the first in point of time. That is, the law has been settled. Now, I can also perceive of a situation that if I am in a constructive possession, I may not be in actual possession. Then also I may be prejudiced by application of 116. As an officer of the court, I am making that submission. Because 116 contemplates of actual possession and abandoning the interest over that particular plot of land.
where in the facts of this case, it's a case of
No,
abandonment.
you say therefore no longer in possession of any interest in the estate.
Yes, any interest.
Interest means it's a very big term.
Hmm.
Interest will include anything whereby he may have any interest over it, which will include interest as regards title and interest in respect to some rights accrued on the basis thereof. The possession cannot be a concept of interest. You cannot take out what these people are doing it. They take out the interest aspect from there and then decide.
Now, what has happened here in the proceedings that was drawn up, which has culminated into passing of the impugned order. Now, in that proceedings, my lord, they were given ample opportunity to lead evidence, my lord, and to justify as to whether they are in possession or not.
Again, I'm saying, it's not a question of possession.
No, I am only on the factum of possession. Let us, for the timing, let us assume the possession, because I will go by 116, because 116, my lord, the factum of possession is the condition precedent. Now, if I read
No.
116.
No,
if lo- if-
116 is not factum of possession. It is the interest on.
no,
No,
in
you
the-
see, everybody forgets this line. Does no longer in possession of any such interest in the
interest,
state.
Possession of any such interest. in the-
Interest, not
Interest.
possession.
Not possession per se, but possession of interest.
Interest.
Yes, meaning thereby, so
If he has a right of title,
no, right of title is something different.
title, if you have awarded, just for example, the fact remains that it is falls within the Pata land.
That there is a pond in the present case, there is a pond.
But whether it falls within the Pata land or not.
Yes, it is part of the Patta land.
So if it falls within the Pata land, if it falls in a, you have issued a title over you have issued a lease over the land Pata through him. Once you have given an interest has been created. Now my question is, has he been paying the land revenue in respect to the Pata?
Yes, in respect of the.
If
whole
that
Patta land,
is
definitely,
being
yes.
paid in respect to the Pata, then how did he give up his interest over the land?
Now, what has called out, my lord, from the, my lord, proceedings, my lord, taken up by the learned the revenue authorities in the district below is that, my lord, sum and substance is that, my lord, they have admitted, my lord, that they are not possessing that pond.
Again, possession is different.
No, my lord, let me, my lord. They are not possessing the pond, and they are not even using the pond. If the pond is being used by public for carrying out rituals, and the pond has been existing there historically.
So what?
That is.
Tomorrow I have a house, I don't use it, I allow the other people, okay, let them use it. So therefore you are going to apply 116. No.
I cannot submit.
I
cannot comment on the reports.
this is not done.
It's-
116 is very different.
Not absolutely right, Vinod. What is the language of any such interest in not physical possession? If I have a patta, end of the matter.
And
I-
he has
I'm
been,
not-
and the most important but the question is, has he paid the land revenue for the
Yes.
patta? Meaning therefore he's not given up the right.
Yes, I'm still paying.
So let me come back, matter simple. I'll order faster dictation.
Yes.
The other is consequential, nothing.
Yes, yes.
That is, my lord. Yes,
Consequential.
Come back, yes. But only one aspect of the matter, my lord, if I may point it out, my lord.
Yes.
We have taken that stand in the affidavit also, that these, while making a settlement, my lord, that entire part and parcel of the land in favor of the tea estate, including the pond, it was a conditional allotment, and at that point of time, my lord, the Latmondal and the concerned revenue staff had, my lord, committed an error in not recording it as a, my lord, specific area which is not to be a part of the settled, my lord, part and parcel of the land. But that stand has
The
been taken.
council, you again fall into another big problem
No, my lord, it
in
may be-
this.
it
You
may be-
see, what have you done as regards at the, no, forget about the Parmaya. This tea state has gone under the Assam Fixation of Land Ceiling Act.
Act.
There you have allowed this pond to be retained. How do you take care of that?
No, want to be retained, my lord, because lordship will see the chitha for a moment.
No, forget about the chita. My question is, see the the draft notification, the final notification, you will see that land. It will be a part of it. Now, if you have allowed it as a part, you see, a bond in a tea state is not only required, many bonds, you see, in a tea state, one has to also understand that for maintaining the, what you call, the moisture in the land, as well as also to make it humid, you need a humid condition for the tea leaves. You see, in all tea states, they have a pond.
Or some water bodies.
No, a big pond. Every tea state has a pond. The reason of having a pond is that because of the moisture it retains, it helps in the, you see, it helps in the growth of the tea leaves.
Feelings and also
The-
retain the flavor.
it grows in the means you need a moisture.
Yes.
Sometimes earlier, some people used to tell me that if it is very sunny, if it just rains out there, it doesn't lead to the growth.
Yes.
What it requires is during the day there has to be sun, and
Yes.
during the night there should be rain.
Yes. Yes.
The
yes.
reason is then it accumulates moisture, and this leads to the growth of the tea leaves. So the pond may be a part of the tea garden, and it has been allowed to be retained. So on the basis that the Lot Mandal made a mistake, but the fact remains as to whether in the final notification, is it there or not? If it is there, you have allowed it to retain, then you can't help it.
No, because here at the proceeding with the, there is no material on record. Even there cannot be any material on record for the simple reason that here is a lease which is not connected with the 1956 Act. Let us be clear with it. They have only questioned, my lord, that order passed.
Not necessary. The moment you are bringing the Lot Mandal's aspect, the
So therefore, if Lordship allows me just 1 minute, if I may read, my lord, paragraph 5, then I will show the chita and that will be my end of my submission, my lord. Paragraph 5, my lord, of the affidavit filed by the district commissioner. Lordship, see, my lord, paragraph 5. My lord, that affidavit, I
Yes.
apologize, my lord, I do not remember the running page. It is filed by, my lord, the deponent is one Vivekananda Fukon. The respondent number 7, the deputy commissioner,
From Dibbanath Morang, an affidavit filed by Dibbanath Morang.
But there's another, that is DC Sipsagar, my lord, that is respondent number 2.
Ah.
I think my learned friend is referring to respondent 7.
7 affidavit. It is filed on 1/8/2017, my lord. 1st of August 2017. The deponent is, my lord, Vivekananda Fukon.
Ah,
Vivekananda Fukon, lordship got it, my lord. I am
Yes.
so obliged. Their lordship will kindly come to paragraph 5, my lord. That will cleanse the issue. There's, as regards the statements made in paragraph 3 of the writ petition, the deponent begs to state that it is not true that the aforesaid tea garden was purchased by the forefathers of the present managing directors from the British along with Sonari Pukhuri, which is a historical monument of the Ahom king. Now, this Sonari Pukhuri is the bone of contention here, and that it was in their possession. It was only in 3/11/2001 that the dark numbers mentioned below, these are the ducks, were included in the pattern number 1 along with other ducks. In the Sodor Zamabandi of the land, the following notes were written clearly against the land allotted to Sonari Tea Company. Historical tank, moidam, etc. stands here. This land shall not be allotted to anyone as per Rule 10(1) of the Assam Land Policy 1989 and as per order of the DC Sipsagar number so and so dated 19/1/2001, countersigned by the SDC Sipsagar dated 21/7/2001. It was an error on the part of the concerned Latmandal to include DAG number 11/8/9/12. When an error is done against an established provision of law, it should be rectified immediately rather than to be continued with the error. In the record of right, in the Zamabandi, it has been clearly mentioned historical tank, moidam, etc. stands here. Now, in the repetition, what has been annexed, my lord, is the Zamabandi. That your lordship will find
my lord, at my lord, page 21. Page 21 of the writ petition. Page 21 of the writ petition.
Are you telling me that in this land, you have not carried out Assam Fixation of Land Ceiling Act?
My lord, that
How can it be? It has to be.
Is it ever heard of?
Well, I do not have instructions because that is not the lease here, my lord.
No, that's not the least means. You see, on one hand, you are exercising 116 and making it Sarkari. That is the lease here. Not the lease what Latmondal had put it in 2001. That is not the lease.
Yeah.
So therefore, once you are exercising 116, you by your actions admit that their name was there, but as they don't have the possession, therefore we are striking it out and making it Sarkari. So if you are transgressing yourself into that aspect, then why not this court would ask you about the Assam Fixation of Land Ceiling Act?
No. Page 21, my lord.
Yes.
On the right-hand side, lordship will see, my lord, মন্তব্য খ। ইথাৰ শ্ৰীযুত চক্ৰ বিষয়া মহোদয় চৰেন্দ্ৰ হুকুম মতে আলু দখল বটোৱাৰাৰ সূত্ৰে আৰু নটিচ একচুৱেলি মতে এই পট্টাৰ টাৱত দাগৰ মাটিত 5, 6, 7 আৰু 8 নম্বৰ স্থলত সোণাই টি কোম্পানী প্ৰাইভেট লিমিটেড নামজাৰি কৰা হয়। So this is the order of mutation, which is reflected in the Jamabandi. Now the Chitha, because I have, my lord, procured the original records. In the Chitha, against, my lord, the mutation being recorded in favor of the petitioner T company, my lord. On the right-hand side, it is written, my lord, historical monument, tanks, modem, etc. stands here. This shall not be allotted to anyone as per Rule 10(1) of the Assam Land Policy 1989 and as per order dated so and so.
So what is the date of that note?
That note is, my lord, 21/7/2001.
And land policy came in 89.
Yes, 89.
And this is continuing from 1800 and something.
This is just stand taken by the, my lord,
I'm happy
authority.
with that.
I need to only appraise that much, my lord.
The land policy came in 89. And this note is of 2001 and we are dealing with a matter of 1800 and odd.
But anyway, you are not stopped from initiating if it is it a one-time affair? Assam Fixation of Land Ceiling Act 56 continues.
Yes, but if the act is not
If the
amended,
final statement has been made in 7, it is there. But if there is again less, you are allowed to retain certain area. But if you are not retaining it, just for example,
Yes,
if you are
I
not
can-
retaining,
Yes.
if you are not using,
I'm so obliged. Yes, I got it. Yes.
that is your lookout.
Yes. Absolutely. Now what has been done might not done. I cannot help you on the records.
No, because what you are making that submission or that affidavit which has been filed goes beyond the purview of the proceedings in the instance.
yes, one.
So once you say that, we have to again take into account the other one and come up with these things which will make it further difficult for you.
No, my lord, since I am in a catch-22 situation, I will take all pleas, my lord, to defend one. That is my sincere endeavor. Only to that extent.
I had Mr. Chaudhary, I had asked last year. There were so many judgments, it was very difficult to get it. When it's trace out where it has been reported and all. So I asked both the law reports out there to kindly make a compilation, a digest of my judgments and all. This is being made by the GLR last year, GLT, and this is made by the GLR. This is just the digest of the judgment.
Achha.
Well, I'm so
But they made it very well. All their reading with all judgments and all.
All reported or unreported also?
No, these are all reported. Have a look at this. I couldn't help.
Silence. Oh, uncle, I really didn't.
They have put a digest, means giving everything out there. Like
No,
just for
that's
example,
very
just now.
Meticulously done.
Very meticulous. Here also, this is the GLR one. They've done it very meticulously. Giving everything.
That's like the regular digest, what is available with the vendors. We get it from vendors.
No, this is only for me. Only one copy they make.
But I was.
But it becomes easier for me.
Yes,
Otherwise,
yes.
it becomes very difficult. Just for example, he said about modern company. I just found it out from there. You know.
M. Yeah. We use data model here. Edit.
So there was the other was an NIT issue.
NIT.
So this is consequential.
Yes, what's
Heard Mr. Kane Chaudhary, the learned senior counsel, appearing on behalf of the senior counsel, assisted by Mr. A. Das, appearing on behalf of the petitioner in both the writ petitions. Mr. Arbor Pujari, the learned standing counsel of the Revenue and Disaster Management Department, appears on behalf of the appears on behalf of
All the revenue authorities, my lord.
all the revenue authorities.
All the respondents, my lord, in the first writ petition, my lord, for all the respondents. And in the second writ petition, my lord.
Of all the respondents in WPC number 6015/2015. And
My lord, in the second writ petition, my lord, I appear for respondents
behalf
number
of the respondent number 2,
2,
3,
3 and 4, 2, 3, 4, 5, 6, my lord.
5, 6
Yes.
in WPC number 1470/2020.
My lord.
PWD. None appears on behalf of the PWD when the matter is called for.
The second writ petition is concerned, my lord, they want to
For
construct a road, my
PWD in WPC number 1470/2020.
second writ petition, PWD had contemplated to construct a road, my lord.
I know this.
Which passes through that historical thing, and that is the issue here. Yes.
Upon hearing the learned counsels appearing on behalf of the parties, it transpires that the outcome of the actions complained of would be dependent upon the adjudication in WPC number 6015/2015. Next. The brief facts which led to the filing of the first writ petition. Well, under such circumstances, this court takes up the first writ petition for adjudication, and depending upon the decision in the first writ petition, this court would take up the second writ petition The brief facts which led to the filing of the present of the first of WPC number 6015, ऊपर लिखी हुई है, 6015/2015. The brief fact, the instant application has been filed challenging the order dated 27/3/2015 passed by the additional Deputy Commissioner Revenue Sibsagar in Miss Case number 5/2014, whereby the land at measuring 35 bighas 1 katha 10 lechas covered by dag number 9, 11, 12 of patta number 1 and 54 of Abhayapur Moza under Honari Revenue Circle was made Sarkari. The brief facts which led to the filing of the present petition is that the petitioner, that the forefathers of the managing director, public directors from purchased a tea-garden in the name and style of Hunari Tea State. The said the Hunari Tea State is situated over a plot of land covered by 34 dags and within KP Patta number 1 of Hunari Grand Abhayapur, Moza, within Honari Revenue Circle in the district of Sibsagar. It is an admitted fact that within the said Honari Tea State, there is a water body covering 35 bighas, 4 katha, 13 lechas, which is situated over dag number 11, 9, 8, 9, and 12 of KP Patta number 1. A proceeding was initiated under Rule 116 of the Assam Land and Revenue Regulation 1886, for short, the regulation, by the Additional District Deputy Commissioner Revenue, Sibsagar. An organization in the name and style of Soraido Mohokuma Tai Ahom Hongsta had approached this court by filing a writ petition, being WPC number 3339/2007, stating inter alia that a water body, which is otherwise called the Hunari Pukuri, was dug in the 16th century during the reign of Ahom king Godapane. The said water body was used for the last 5 centuries as a Thai Ahom community for the rituals in the Medam Mafi and Trasinfa festivities. On account of certain interference caused to these Thai Ahom people, on account of certain alleged interference caused to the Thai Ahom people, the said petitioners approached this court by filing a writ petition being WPC number 339/2007. In the said affidavit, which was filed by the additional deputy commissioner, Sipsagar, in the said writ proceedings, it was admitted that the pond was used for festive rituals and recreational purpose, and water from Hunari Pukuri was used for irrigation purpose by the local cultivators. It was also mentioned that a proceedings was initiated under section 116 of the regulations, and there was a direction passed by the learned single judge, learned coordinate bench of this court by an order dated 14/10/2014, that the said proceedings under section 116, under rule 116 of the regulation, be brought to a logical conclusion within a period of 3 months from the date of the said order. It is the case of the petitioners that the petitioners were unaware of these proceedings under section 115 till the order was passed by the learned coordinate bench of this court dated 14/10/2014 in WPC number 339/2007. It is further seen that on the basis of the said proceedings which was initiated, which was registered as Miss Case number 5/2014, the impugned order was passed on 27/3/2015, whereby it was opined that the petitioner had no possession over the land for long years, and the disputed land has been used by the public. Accordingly, the circle officer, Hunari Revenue Circle, was directed to strike out the name of the petitioner from the record of rights, that is, from land documents, and convert the land to general Sarkari land and kept reserved for public purposes. Being agreed by the said order dated 27/3/2015, 15, the present petition was filed by this court, filed before this court. On 28/9/2015, the record reveals that this court, by an order dated 5/10/2015, while issuing notice, directed status quo be maintained. The said interim order thereupon have been extended from time to time and still continues. The record reveals that affidavit in opposition has been filed by the respondent authorities, thereby justifying the order dated 27/3/2015. In addition to that, in an additional affidavit which was filed by the District Commissioner, Hokkaido District, on 1st of August 2017, it was mentioned that the recording of the said land, the water body, into the patta of the petitioner's land was an error on the part of the concerned Lot Mandal. In the backdrop of the above, this court now finds it very pertinent to take note of the second writ petition, which is WPC number 1470/2020. The reason for filing the second writ petition was that certain actions were taken by the PWD department to construct a road over the land wherein the water body is situated. The record reveals that by an order dated 3/3/2020, the learned coordinate bench of this court, while issuing notice, had directed that the status quo order dated 6 passed in WPC number 6015/2015 shall stand extended to the water body which is protected. Water. The question, therefore, which arises in the instant proceedings is as to whether the respondent authorities, more particularly the additional Deputy Commissioner, Revenue, were justified in passing the order dated 27/3/2015, more so in exercise of the powers under Rule 116 of the settlement rules. ওতে আমি লেখা আছে রেগুলেশন লেখা আছে রুল 116 of the settlement rules, framed এইটো মই রেগুলেশন বুলি কৈ আছো, rule 116 of the settlement rules. For that purpose, this court finds it pertinent to take note of Rule 116 of the settlement rules, which is reproduced herein under. Perusal of the above quoted rule would show that whenever it comes to the notice of the Deputy Commissioner that any person whose name is recorded in the General Register as a proprietor, settlement holder, or manager of any estate is no longer in possession of any such estate in the any interest in the estate is no longer in possession of any such interest in the estate. To underline, the Deputy Commissioner may order the name of such person to be struck off from the register. The expression no inverted comma, no longer in possession of any interest in the estate, inverted comma, is of vital importance in as much as it is only when a person does not have any interest in the estate the power can be exercised. The said expression under no circumstances can be equated with a situation when the person is not in possession of the land in question. It is the further opinion of this court that if any other interpretation is given to the said expression, comma, it is the further opinion of this court that if an interpretation is given that a person who loses possession to another, the person's name is required to be struck off, it would result in a chaotic situation. And further, the rights which have been constitutionally and statutorily granted would become authorized. This court also finds it relevant to take note of a judgment of the court net bench in the case of Bhavani Shankar Bagaria versus State of Assam and others, reported in 2008 for GLR 134. Paragraph 5 of the said judgment, being relevant to the issue, is reproduced hereunder. Principle next. The principles so laid down by the learned coordinate bench in the backdrop of the above principles, comma, the question therefore arises as to whether the additional district commissioner revenue would have at all exercised the powers under Rule 16 of the settlement rules. The petitioners herein claim and have been claiming that the water body is within their lands, and this aspect and the fact that the water body is within the petitioner's land is also not in dispute, taking into account the very order dated 27/3/2015 passed by the impugn order dated 27/3/2015, as well as the initiation of proceedings under Rule 616 against the petitioner. First, this court have now perused the order dated 27/3/2015, and the reasons so assigned in the said order is that the petitioner is no longer in possession of the water body and the public have been using it. Rule 116 of the settlement rules do not merely state about possession, but it refers to possession of interest in the estate. There is also no quarrel with the proposition. There is also no quarrel with the fact that the petitioners have been duly paying the revenue in respect to the patta in question. Under such circumstances, it is therefore the opinion of this court that the Rule 116 of the settlement rules could not have been invoked in respect to the water body in question. Taking into account that the petitioner continues to retain interest continues to have possession or continues to have interest in the estate, possession of the continues to have possession of interest in the estate, which includes the water body. The fundamental mistake committed by the learned by the additional district commissioner of revenue is apparent from a perusal of the impugned order dated 7/3/2015. And therefore, the same cannot be sustained in law. Next. Let this court now deal with the actions so taken for construction for issuance of an NIT for construction of road over the water body. Over? It can't be over.
The NIT says, my lord, in the second repetition, Lordship will find that NIT at page 56.
For what?
It is, my lord, stated the name of the work is infrastructure upgradation to Sonari Pukuri Approach Road.
For,
Page
for
56.
construction of infrastructure, the second NIT is for infrastructure
Upgradation.
upgradation
For a moment, if Lord-
for the approach road. Take on the option.
Page number 58A.
56 available. The part of the repetition. Second repetition.
Infrastructure upgradation.
Infrastructure upgradation to Unari Pukuri approach road, historical Pukuri.
Serial number 4.
The said construction has to be made over the land of the petitioner, wherein over the land which have been leased out to the petitioner by granting of patta. In the opinion of this court, the PWD authorities could not have issued the notice inviting tender dated 24/1/2020 insofar as the infrastructure upgradation to Sunari Pukuri approach road till the land vests with the petitioner. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugned order dated 27/3/2015 passed by the additional Deputy Commissioner Revenue in this case number 5/2014 is set aside and quashed. Number 2. The impugned notice inviting tender dated 24/1/2020 insofar as the notice so far as the bids sought for in respect to infrastructure upgradation to Funari Pukuri approach road bracket historical Pukuri is interfered with. It is clarified that this court have not interfered with the other works which have been mentioned in the detailed notice inviting tender. Anything more? There shall be no order as to cost.
And so,
That is over.